ಕೆಳಗಡೆ ಸೆಕ್ಷನ್ ಮಲ್ಲನ್ನ
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಕ್ಕೆ
ಆಯ್ತು
ಬೇಕಲ್ಲ
ಇಲ್ಲ ಪೇಜ್ ವೈಸ್ ಕರಿತೀನಿ ಕೇಳಿ ಹೇಳಿ
ಕೇಳ ಒಂದು ಮಂಡೇ ಅರ್ಜೆಂಟ್
ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಕೇಳಿಸ್ತಾ ಇದೆ. ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಕೇಳಿಸ್ತಾ ಇದೆಯಮ್ಮ, ಕೇಳಿಸ್ತಾ ಇದೆ.
ಅವ್ರ ವಾಯ್ಸ್ ಬರ್ತಾ ಇಲ್ಲ ನಮ್ಗೆ.
ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಸರ್ ನೀವು ವಾಯ್ಸ್ ಮಾತಾಡಿ ಒಂದು ನಿಮಿಷ, ಇಲ್ಲಿ ನಮಗೆ ಆಡಿಬಲ್ ಇಲ್ಲ.
ಕೇಳಿಸ್ತಾ ಇದೆ ನೋಡಿ, ಈಗ ಕೇಳ್ತಾ ಇದೆಯಾ?
ಎಸ್ ಸರ್, ಥ್ಯಾಂಕ್ ಯು. ಮಧ್ಯಾಹ್ನ ಎಲ್ಲ ಫುಲ್ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ. ಟೀಚರ್ ಮೇಲೆ ಅದೇ ಬೇರೆ ಮಾಡ್ತೀವಿ. ಹೇಳಿದ್ರು ವಿಶ್ವಿಗೆ ಯಾವುದು ಹಾಕೊಂಡಿಲ್ಲ ಅದರಲ್ಲಿ ಡೇಟ್ ಬರ್ತಲ್ಲ ಸ್ಲಿಪ್ಪಲ್ಲಿ ಮೆಮೋಸ್ ಕೊಟ್ಕೊಡ್ತಿರಲ್ಲ ಸರ್, ಅವಾಗ ಈ ಫೈಲ್ ಇವಾಗ ಮೇನ್ ಮೆಮೋ ಬರುತ್ತೆ, ಅದು ಬರ್ದಾಗ ನಮ್ಗೆ ನಿನ್ನೆದೆಲ್ಲ ಇದೆ. ಯಾವ್ದಾದ್ರು ಸೌಂಡ್ ಬಿಟ್ರೆ ಅವಾಗ ಒಂಚೂರು ಲಿಸ್ಟ್ಗಳೆಲ್ಲ ನಿಮ್ಮ ಹತ್ರ ಇಲ್ಲ. LSCಗೆ ಬಸವರಾಜ್ ಕುಡಾಚಿ LSCಗೆ ಬಸವರಾಜ್ ಗೊಡಾಚಿ AG ಗೊಡಾಚಿ GODACH CH ಅವ್ರ LSC ಬೇರೆದಕ್ಕೂ LSCನೇ ಇವಾಗ ಬರ್ತಾ ಇರೋದು, ಇನ್ನೆಲ್ಲ ಕ್ರಿಮಿನಲ್ ಬರ್ತಾರೆ. ಅದೇ ಅವರು ಲಕ್ಷ್ಮಿ ಯಶೋಧ
Which matter, my lord?
subject to complaints. Adjournments, page wise, page 1, seal number 1. Page 2, seal number 2 and 3.
Seal number 17.
Page 3, seal number
17.
4 and 5.
Oh.
Page 4, seal number 6 to 9.
Alas.
Page 5, seal number 10 to 13. Page 6, seal number 14 to 17.
17. You have it on Wednesday.
19.
Oh, seal number 17. You have it on Wednesday.
Whom do you represent here?
I am for the appellant.
It was once already dismissed.
Yes, please.
Matter started in 19.
Filing and recalling
Right,
applications.
again for recalling, why do you want it?
Alas, senior counsel is attending. Please have.
Yes. Who is for the other side here? Jaikar Shetty.
Jaikar Shetty.
Wednesday.
We had already dismissed it, saying that.
Yes,
Yeah,
this is
that-
non-prosecution. This is non-prosecution was dismissed.
Yes, non-prosecuted 1991 in the case nadita ಇದೆ.
ಅಲ್ಲ ಸ್ವಾಮಿ ಅಂದಡ್ಡೆ ಅವರೇ ಕೋಆಪರೇಟ್ ಮಾಡಿಲ್ಲ ನಾವು ಎವ್ರಿ ಟೈಮ್ ಇದ್ದು ಸ್ವಾಮಿ ದೇ ಆರ್ ನಾಟ್
Still had recorded everything. Again, after filing recalling application also, you want adjournment.
ಅದು ಏನಾಗಿದೆ ಅಂದ್ರೆ ಲಿಂಕ್ ಇಸ್ ನಾಟ್ ಲಿಂಕ್ಡ್ ಸೊ ದಟ್ ಇಸ್ ವೆರಿ ಡಿಫಿಕಲ್ಟ್
Please, try to see if there is any problem in the link. You could have mentioned it earlier only in the registry.
ವೆಡ್ನೆಸ್ಡೇ yes I have tried ತುಂಬಾ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್
First
ಆಗುತ್ತೆ I will request ಬುಧವಾರ
For the appellants, it's adjournment. This matter was already once dismissed for non-prosecution.
ಅಲ್ಲ one submission senior will take and see I'll try to say yes seniors come
Pass ಕೊಡ್ತೀವಿ ಅಂತ ತಕ್ಷಣ ಮಾಡ್ತೀವಿ.
no it's link ಅದು ಆಗ್ತಾ ಇಲ್ಲ ಅಂತ ನೋಡಿ called me Satish is
May I please your lordships?
yes
Lord, in item 17, my colleague is making a mention.
Satish Sundar yes
My name is Satish Sundar, my lord. I am appearing along with Prasad
All right,
in this
all right.
matter.
We'll take it up. We'll take it.
please ಅದು ಸ್ವಲ್ಪ
Yes.
ಆಗ್ಬೋದು
I'll be there. I'll be present at the matter.
Next.
Page 7, seal number 18 to 20. Page 8, seal number 21. Page 9, seal number 22 to 23.
23, my lord. I am for respondent KSFC. I seek a week's accommodation, not accommodation.
1477 days. to
ಅದಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕಾಗಿದೆ, ಮೊನ್ನೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಕಾಪಿ.
2021 in the period. At the request of
1477 days.
Finally, 1 week time is granted to file counter to IA 2021.
Yes.
Yes, 1 week.
Page 10, seal number 24 to 27.
Serial number 26, my lords. I am for the R2. Senior is not feeling well. A week's time may be granted, my lords.
You are for?
R2, my lords. A week's time.
Kalat not filed. Chandrasekhar. V. Chandrasekhar.
I am for Ranjan Kumar K.
Yeah, ವಕಾಲತ್ ಹಾಕಿಲ್ಲ ಅವರು. Vacating stay is filed by whom? By you or respond number 1?
R1, my lords.
ಅವ್ರು ವಕಾಲತ್ತೆ ಹಾಕಿಲ್ಲ, ನೀವೇ ಹಾಕಿರ್ಬೇಕು vacating stay. Adjourned at the request of counsel for respond number 2. Yes.
Page 11, seal number 28 to 33.
Seal number 28, please, my lord, is there, I'm for the,
Serial
28, please, my lord. I am for the proposed respond number 3. I filed my wakalat, I have to file my objections to the application, please, my lord. Week accommodation may be granted, please, my lord.
Notice serve ಆಗಿತ್ತಾ?
Agi so.
SFC. ಇದನ್ನ ಪರ್ಚೇಸರ್ ಅಂತ ಕೇಳಿದ್ರು.
How's? Week accommodation may be granted.
Adjourned at the request. Well, appeal against R2 stands dismissed. Venkatesh P. Dalwai for
R3,
proposed
proposed,
respond number 3.
please.
At request of Karnataka council for proposed response 3, 10 days time is granted to file counter to IA 2023. Yes,
Much.
next.
Page 12, Still number 34 to 38.
Serial number 38, my lord.
Hmm.
I pray 2 weeks time, my lordship. We have no communication. I am for the appellant in this matter. We have no communication with the time, my lordship. So we want.
Admission ಗೆ communication ಆಗ್ಬೇಕು. You have to argue the matter.
Please, my lord. I pray for 2 weeks time, my lord.
Finally, sir. ಅಪೀಲ್ ನಾಟ್ ಅಡ್ಮಿಟೆಡ್ ಅಂತ ಬರ್ದಿದ್ದಾರೆ. ಫೈನಲ್ ಇಯರಿಂಗ್ ನಲ್ಲಿ ಲಿಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅದನ್ನ. ನೋಡೋಣ ಅದು ಬಂದಾಗ admit ಮಾಡಿ.
My lordship, 2 weeks time. Right, inconvenience.
Okay, sir. ಸರಿ adjourn ಮಾಡೋದಕ್ಕೆ we have some inconvenience in adjourning. The matter is not even admitted 2017 matter. You can argue if your senior is not available for admission. Yes.
Page 13, still number 39 to 42.
Serial number 42, kindly have it and next week.
Serial number 40.
Today is inconvenience to,
Mission,
There are two matters.
Yes, ma'am.
Ah.
I'm for the
There are
respondent.
so many, somebody has filed memo of retirement, so many applications are there.
That
Connected.
item, my lord, serial number 42, I'm for the caveat respondent.
Huh.
The council is not in station, my
They are
lord.
not
She is in USA. Kindly have it on the July first week, my lord.
ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನೋ ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ acknowledgement for having served set of papers to respondent. ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದಾರಾ?
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ವಿ ನಾವು petitioners.
You aware?
I have to get the information. She is not in station, madam. She out of country, my lord. Kindly have it on July first week, madam. Gayatri runs.
Compliance ಆದ್ರೂ ಆಗ್ಬೇಕಲ್ಲ. At least she should tell whether copies are served or not. ಇದೆಲ್ಲ ಹೇಳುವಾಗ ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ದ affidavit regarding assets and liabilities by counsel for respondent and appellant. Vacating interim order. Next matter, memo of retirement filed by advocate for the appellant. ಯಾರದು ಹಾಕಿದ್ರು? ಸುಭಾಷ್ ರೆಡ್ಡಿ. ಜಗದೀಶ್ ಮಂಡಲ್. Yes, right. Somebody has appeared.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಎರಡನೇ ಕೇಸಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ನಾವು ವೆಕೇಟಿಂಗ್ ಸ್ಟೇಗ್ ಹಾಕಿರೋದು ನಾವೇ ಸುಮ್ಮದ್ರಲ್ಲೇ.
ಆಯ್ತು, ಅದ್ರಲ್ಲಿ ಸುಭಾಷ್ ರೆಡ್ಡಿ ಅಂತ ಇದ್ರಲ್ಲಿ
ಹೌದು.
ಹೀಗಿದ್ದಾರೆ. ಫಸ್ಟ್ ಜಗದೀಶ್ ಕುಂಡ್ರಿಗೆ ಇದ್ರ
ಅರ್ಲಿಯರ್ ಇದ್ದಿದ್ದು
ಅದು ಅಷ್ಟೇ 42.1 ಅಂತ ತಗೊಂಡು
ಅದೇನ್ ಸೆಟಲ್ಮೆಂಟ್ಗೆ ಮಾತಾಡ್ತಾರೆ ಅಂತ.
ಫಾರ್ ದ ಅಪೆಲೆಂಟ್ ಪಿ ಜಗದೀಶ್ ಕುಂಡ್ರಿಗೆ ಲೆವೆಲ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಪರ್ಮಿಟೆಡ್ ಟು ರಿಟೈರ್. ಮೆಮೋ ಆಫ್ ರಿಟೈರ್ಮೆಂಟ್ ಇಸ್ ಡಿಸ್ಟ್ರಿಬ್ಯೂಟೆಡ್ ಅಕಾರ್ಡಿಂಗ್ಲಿ.
ಹೌದು.
As requested by both sides. As a final chance, list on the date.
19.
July first week, she is not in country, my lord. For the reason.
ಅದರ ಮಾಡ್ಬೇಕಲ್ರಿ 2010 ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಮ್ಯಾಟರ್ಸ್
ಇಲ್ಲ settlement ಅಂತ ಇದು date ಹೋಗ್ತಲ್ಲ ಇದು.
See, we are seeing a tendency. Whenever they are listed for final hearing, advocates come up with a statement that the parties are trying to settle. 6 ವರ್ಷ ಏನ್ ಮಾಡಿರ್ತಾರೆ ಈಗ? 2007 years, not 6 years.
ಡಿಸ್ಪೋಸಲ್ ನಾವು ಬಹಳಷ್ಟು ಟ್ರೈ ಮಾಡಿದ್ವಿ, ಅವರೇ ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಟೈಮ್ ತಗೊಂಡ್ರು. ಸೊ ಈ
ಪಾರ್ಟೀಸ್ ಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಮುಗಿಸ್ಬಿಡಿ. ವೈ ಶುಡ್ ನಾವು there is everything is being thrown on the judiciary saying that there is delay. ಅದು ನಿಜಾನೇ, ಪಾರ್ಟಿ ಸಫರ್ ಆಗ್ತಾರೆ ಇದರಿಂದ.
only 1 month ಮೇಲೆ ನೆಕ್ಸ್ಟ್ July first week.
ಏನಾದ್ರೂ ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಷ್ಟರಲ್ಲಿ. We cannot facilitate the lawyers to fly and get the matters listed for 1 year. Request finally, as requested both sides, finally list on date. 19. ಯಾರಾದ್ರೂ ಒಬ್ಬರಿಗೆ ಅರೇಂಜ್ಮೆಂಟ್ ಮಾಡ್ಬೇಕಲ್ಲ ಇಲ್ಲಿ. You can take the file, read the file and argue the matter.
26.
Serial number 41.
Serial number?
Serial number 41 connected.
Page 14, serial number 43 to 45.
41, my serial number 41.
Serial number?
1 week time petition connected matter.
ಅಲ್ಲಿ ಎಷ್ಟು ನಿಮ್ಗೆ ಸೀರಿಯಲ್ ನಂಬರ್?
Serial number 41.
41 ಕರೆಸ್ದಾಗ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ನೆಕ್ಸ್ಟ್ ಕರೆಸ್.
Page 14, serial number 43 to 45. Page 15, serial number 46 to 51. Page 16, serial number 52 to 56.
56.
Serial number 55, my lords. Advocate on record is not keeping well. So pray for a 2 weeks adjournment, my lords.
My lord, I'm for the respondent in serial number 55.
56.
2 weeks time may kindly be granted. My lords, the advocate on record is having medical issues. She's on bed rest, my lords. So 2 weeks may kindly
I'm
be
for the
granted.
respondent in serial number 55, my lord. I'm ready for the arguments.
ಗ್ರೌಂಡ್ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ 2021.
This is a 2021 matter, yes, ma'am.
ನಮ್ಮ ಮೆಡಿಕಲ್ ಗ್ರೌಂಡ್ ಅಂತ ಹೇಳ್ತಾ ಇದಾರಲ್ಲ.
Yes, my lords.
ಏನು
But if a date may be fixed in that case.
What is the problem, madam?
No, she had been to outside country. She had a fall and some.
ಮೆಡಿಕಲ್ ಗ್ರೌಂಡ್ ಅಂತ ಹೇಳಿದ್ರಿ, ಔಟ್ಸೈಡ್ ಕಂಟ್ರಿ ಅಂತ ಹೇಳ್ತೀರಾ?
No, she had a fall at outside country and now on treatment because of some back issues and the backbone, some problems are there.
Then you can argue the matter. We
Next
know you are
time,
also very seasoned.
Yes, please, my lords, today only, next 2 weeks time, I kindly be granted.
No.
My lord, if I may request for a date to be fixed in this matter.
ಕಾಸ್ಟ್ ಹಾಕಿ ಕೊಡ್ತೀವಿ, ಇನ್ನ ವಿ ಇಂಪೋಸ್ ಕಾಸ್ಟ್ ಅಷ್ಟೇ.
Kindly.
Lord counsel for the appellant seeks adjournment. Lord counsel for the respondent opposes the adjournment. 2 weeks ಗೆ ಏನಾದ್ರೂ ನಿಮ್ಗೆ ಪ್ರಾಬ್ಲಮ್ ಇದೆ?
I have no objections, but a date, I need a date to be fixed.
ಮೆಡಿಕಲ್ ಗ್ರೌಂಡ್ ಅಂತ ಹೇಳ್ತಾರೆ.
26.
As a finance as this time, 20th June. 20th. 56.
Next week's accommodation.
ಇದ್ರಲ್ಲಿ ಎಷ್ಟೊಂದು ಏನೇನೋ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಮೆಮೋ ಎಲ್ಲ ಇದೆ ಅಲ್ರಿ. ಅಟ್ಲೀಸ್ಟ್ ಅವನಾದ್ರೂ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೋದಲ್ಲ. What are these memos? There are several memos. At least ಅವನಾದ್ರೂ ಡಿಸ್ಪೋಸ್.
Interim order was granted subject to deposit of 30%. All the amounts have been deposited.
Whom do you represent here?
I represent appellants.
Who has filed these IAS and memos? IAS memos ಎಲ್ಲ ಯಾರು ಹಾಕಿದ್ದಾರೆ?
Some cross objections also have been filed by the respondents.
Yes, we are seeing.
The week's accommodation next date, I think we will make submission.
2020 as requested by the administration, the request of appellants. Finally, how much time you want?
The week's.
1 week.
For respondents, land is acquired and compensation is awarded. Against that, I filed a LAC. Compensation is increased. They have come that the compensation amount is more. I have filed cross objections stating that compensation is less.
Correct, ಅದೆಲ್ಲ ಗೊತ್ತಾಯ್ತು. What do you want to say? He is seeking adjournment 1 week time.
Please, a date will fix.
You file, because they arise out of the common judgment, you file the synopsis of your arguments.
Yes, please,
Once.
please.
First 1 week, adjourned by 1 week. In the meantime, the parts, both counsel shall file their synopsis of their arguments. Yes. Because there are many matters.
Yes, we will file synopsis.
All 18 matters.
Please, not 18 matters. 9 matters is our.
Second
set I will file in one of.
Cross objection.
Please.
At least ಅದನ್ನಾದ್ರೂ ನೋಡ್ತೀವಿ ಅಂತ ಹೇಳ್ಕೊ.
All
Non
cross
filing of memo of appearance and ವಕಾಲತ್. ನೀವು ಕೆಲವೊಂದ್ರಲ್ಲಿ memo of appearance
I will
ವಕಾಲತ್
file
ಹಾಕಿಲ್ಲ.
that. I will file.
In the meantime, the pending office objection shall be complied. Memo of appearance ವಕಾಲತ್.
Cross objections.
16.
One of the cross objections, I have to file
Second
second
set of
set.
the appeal memo, the cross objection, appeal memo. Second set of the cross objection has to be filed. Yes, Mr. Chandrasekhar have to file.
Please, I will file second set, my lord. In that case, he may be directed to take notice.
I will take notice.
ಅವ್ರ ಹೆಸರು ಆಲ್ರೆಡಿ ತೋರಿಸಿದ್ದಾರೆ, ಎಲ್ಲೆಲ್ಲಿ ಮೆಮೋ ಆಫ್ ಅಪಿಯರೆನ್ಸ್ ಹಾಕಿದ್ರು ಹಾಕಿ. Yes.
I will file second.
Page 20, seal number 57.
1 week ಅಂತ ಹೇಳಿದ್ರು. You comply.
Serial number 35, my lord. Serial number 35 is a part of the matter, my lord. I appear for respondent. My lord, I want some short accommodation, 2 days, my lord.
Further arguments ಅಂತ.
Further, my lord, I want to argue, my lord, it's
ಅವ್ರ
a.
absence ಅಲ್ಲಿ ಮಾಡೋದಿಲ್ಲ.
Alla,
Last time
they filed the appeal challenging the exported decree of drivers, my lord. It decrees in my favor, my lord.
It is parted matter. Last time ನೀವು ಬಂದಿರ್ಲಿಲ್ಲ.
Alla, vanilla, I was held up with some other court, my lord. Tomorrow, my lord.
Yes, next case. ಬರೀ ನಾವು ಆರ್ಡರ್ಸ್ ಮಾಡೋದಷ್ಟೇ ಆಗ್ತಾ ಇದೆ, ಒಂದು ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಆಗ್ತಾ ಇಲ್ಲ. ಸಾರಿ, ದ ವೇ ಯು ಆರ್ ಕೋಆಪರೇಟಿಂಗ್ ಫಾರ್ ದಿಸ್ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ಸ್ ಹಾಗೆ ಉಳಿಯುತ್ತೆ.
Alla, my lord, it's part of, I want tomorrow, my lord, at least tomorrow.
ಅವ್ರು ಬರ್ಲಿ, ಅವ್ರ ಅಬ್ಸೆನ್ಸ್ ಅಲ್ಲಿ ಬೇಡ. Yes, you cannot mention it in the absence of other side.
For order seal number 1, Sharad Gowda GB.
Hearing for the appellant, your lordship. Filed a memo seeking withdrawal of the appeal, your lordship. Settle ಆಗಿದೆ ಸ್ವಾಮಿ ಮ್ಯಾಟರ್, ಜಾಯಿಂಟ್ ಮೆಮೋ ಜೊತೆ ನಾನು ಫೈಲ್ ಮಾಡಿದೆ.
ಲೋಕದಲ್ಲಿ ಸೆಟಲ್ ಆಗಿಲ್ಲ. Counsel for the appellant, file memo. ಇದೆಲ್ಲ ಒತ್ತಿ ಕೊಟ್ಟಿರೋದು memo, reporting memo, reporting that the matter is settled in local class and 6 dismissal of the appeal as withdrawn. Recording the memo, appeal is dismissed as.
Your lordship, direct, maybe registry director to refund the court fee, your lordship.
Done.
ಹೌದು.
Registration refund the admissible court. Yes. Repeat the appellant.
Still number 2, Raju Bhatt.
Thing is to dispose of, there is one IA. Shall be our.
Lord, I pray for just 2 days time to take steps, my lord.
Number 2.
So far as that GPA is concerned, my lord, all other appellants executed a release deed in favor of appellant number 1A and 1E.
On filing of. Order sheet is ತಪ್ಪಾಗಿದೆ 2016 ಅಂತ. Look at the order sheet. No office objection complaint.
There was-
What are the office objection?
There was some technical error, my lord.
E, E, F and G.
My lord, they have executed a release deed in favor of appellant number 1A and 1E. Appellant number 1A and 1E.
You have filed this appeal
Yes, my lord.
claiming that you are the power of attorney holder
Yes, my lord.
of all the appellants. Now, as per the office objection, no power of attorney is forthcoming so far as appellant number B, D, E, F and G.
My lord, they executed a release deed, my lord, in favor of appellant number 1A.
When was that?
My lord, I have produced copy of the
Have
release
you
deed.
stated that and
Yes, my lord, I have stated in the,
was not, when that release deed was executed?
pardon, my lord,
When that release deed was executed?
my lord, 1/12/2017, my lord,
1/12,
2017.
2017.
Yes,
This award is passed in 2010. Appeal is filed in 2016 after filing the appeal. But we should hear them also. Who knows whether they have executed or not executed?
Lord, it's a registered release deed, my lord. It's a registered deed, my lord.
First 1 week time is granted to the people, failing which the appeal of appellant number 1, B, D, E, F and G and appeal against respond number 3. Who is respond number 3?
My lord, he was one of the claimant before the reference.
Dismissed. Yes. You only have mentioned in the appeal memo that he refused to execute the Wakalatara GPA.
Yes, my
So,
lord. Therefore, he
therefore-
started as one of the respondent.
As on the date of the filing of the suit, there should be a GPA. This execution of the release deed is subsequent to the filing of the appeal. Appeal should be filed by a competent person. According to you, only this GPA.
I will take instruction, my lord, within 1 week.
You have passed order for dismissal of the appeal if it is, full is not done.
Number 3, M. Shivaprakash.
HCDP for RC.
For the appellant, my lord. Respondent number 2 passed away, my lord.
ಬಂದ್ರೆ ಅದ್ರಲ್ಲಿ steps
ಎಲ್ಲರ application office.
not filing of memo, along with acknowledgement for having served the copy of appeal memo on HCCP. Copy ಬಂದಿದೆ. Copy serve ಮಾಡಿಲ್ವಾ?
Alright.
Copy ನ serve ಮಾಡಿಲ್ವಾ?
Serve ಮಾಡ್ತೀನಿ.
2016
Course of-
matter.
Please, my lord. Course of the day, I will serve it.
Who is respond number 3? Remand number 2. This matter is pending since 2016. Death ಯಾವಾಗ report ಆಗಿದೆ ನೋಡಿ?
12/22.
22 ನಲ್ಲ? Death of respond number 2 was reported on
12/22.
12/12/2022 by through postal endorsement. Therefore, appeal against respond number 2 stood abated. Learned ACA submits that copy is not served on him. Finally, 3 days time is granted to serve the copies, failing which appeal shall stand dismissed.
Okay.
ಈ ಒಂದು ಕಾಪಿ ಇಲ್ಲೇ ಇರ್ತಾರಲ್ರಿ ಕೊಡಕ್ ಎಷ್ಟು ಟೈಮ್ ಬೇಕು ನಿಮ್ಗೆ?
ಇವಾಗ
Still number 4,
ಕಾಲೇಜ್ ನಿನ್ನೆ ಸಾಯಂಕಾಲನೇ ಬಂದಿರುತ್ತೆ ಒಂದ್ ಜೆರಾಕ್ಸ್ ಮಾಡಿ ನೋಡಿ ಅವ್ರಿಗೆ ಕೊಟ್ರೆ ಆಗುತ್ತೆ ಇಲ್ಲನೆ.
still number 4, Yadava K. Sanghmeshwar Patil, AV Gangadhar.
I have for the appellant, my lord. This case, first objection, they got to go NOC, my lord. Now the Yadav become district judge, my lord. Our district judge,
Non-filing
deciding
of
officer.
Wakalatara
PO.
Sanghmeshwar Patil. case of office subsections and I 1 and 2 of 2023. I 1 of 2022 is for 1759 days delay in recalling. Oh, recalling nale 1759.
We have not been served a copy of the.
Dismissed on 19/8/2017.
Yes, ma'am.
And you have not even filed wakalat.
No, my lord, he became, Yadav became judge, my lord, presiding officer, PO of district judge, he elevated as well.
They are not able to get you. Any agree?
Now he is a district judge, my lord. That Yadav.
ಆಯ್ತು ವಕಾಲತ್ ಹಾಕೋದಕ್ಕೆ ಅವ್ರು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್ ಆದ್ರೆ ನೀವು
I
ಪಾರ್ಟೀಸ್
already-
ಕರೆಸಿ ವಕಾಲತ್ ಹಾಕೊಳ್ಳೋಕೇನು?
We have filed wakalat, my lord. We have not taken
filing
NOC.
of ವಕಾಲತ್ by ಶ್ರೀ ಸಂಗಮೇಶ್ ಪಾಟೀಲ್ ಅಂತ ಇದೆ. When did you file the ವಕಾಲತ್? NOC not obtained. ವಕಾಲತ್ ಹಾಕಿ ಇಲಾಖ ಹಾಕಿ ಬರ್ದಿದ್ದಾರೆ ನೋಡಿ ವಕಾಲತ್ ಅದು ಬರೆದು ಹಾಕ್ಬೇಕಲ್ಲ ಆಫೀಸ್ ಸಬ್ಸೆಕ್ಷನ್ ಗೆ. ಹಾಗಿದ್ರೆ
Sir, I have to
respond to it in writing.
Please, ma'am. Please, I will write.
And
Weeks time may be granted. I will comply.
NOC ವಕಾಲತ್ to be filed ಅಂತ ಇದೆ ಅಂತ. ವಕಾಲತ್ ಯಾವತ್ ಫೈಲ್ ಮಾಡಿದಿರಿ ತೋರಿಸಿ. NOC not obtained ವಕಾಲತ್ filed in only IA 2 of 2022 ನಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. IA 2 ನೋಡಿ ಅದ್ರ ಜೊತೆಗೆ ವಕಾಲತ್ ಇದೆ ಅಲ್ಲಿ ರಿಕಾಲ್ NOC ತಗೊಂಡಿಲ್ಲ ಅಂತನಾ ವಕಾಲತ್ ಹಾಕಿಲ್ಲ ವಕಾಲತ್ ಚೆಕ್ ಮಾಡಿ ನೋಡಿ
Weeks time may be granted, ma'am. I will come.
Not served on this.
You don't get that appellate. Memo along with it, I served the copies to the council for urban and local. ಇಷ್ಟದು IE 1 of 2022 and 2 of 2022.
But none of the applications have been served on the served by the applicant.
ಸಂಗಮೇಶ್ ಪಾಟೀಲ್ ಅಂತ ಇಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ 1 of 2022. When did you file this wakalat?
Please, ma'am.
2022.
22, ma'am.
When that person became the district judge?
18, my lord, 18 or 19.
Correct. Then you should mention it in the.
Please.
Council is directed. Last time ಹೇಳಿದಲ್ಲ 510. Council Sri Gurudatta for appellant is present before the court physically and represents Sanghamish Patil, but he has not obtained NOC issued by other. Therefore, council is directed to do the needful.
Three or 311.
Are you aware what are the order dated 19/8/2017?
2007.
2 weeks time is granted to remove the office subsections, failing which the matter shall stand. Oh, ಅದರಲ್ಲಿ dismiss ಆಗಿತ್ತು ಅನ್ನೋದಿಲ್ಲ. Then next ಮತ್ತು office subsections comply ಮಾಡಿಲ್ಲ.
Yes,
Then
ma'am.
recall ಆಗಿತ್ತ. Why it was recalled? Automatically dismissed. 14/11, 19th August 2017. Remove the office subsections, failing which the matters. IA 1 of 2022, recalling the order dated 19/8/2000. Why two application, Mr. Council? Two sets of application?
Delay and recalling. Good.
No, it was dismissed on 19/8/2027. I'm sorry, 2017.
Yes, ma'am.
Why? You have filed two sets of application for recalling. 19/8/2017. File ನೋಡೋದಿಲ್ಲ, ಏನು ನೋಡ್ಕೊಂಡಿರೋದಿಲ್ಲ.
Sorry, ma'am.
14/11/2022. What is the order? 14/11. But there is no representation in this matter. Is filed seeking condone delay. Therefore, issue notice of IA 1 inclusive of notice on appeal against respondents. List 2 weeks ಅಂತ. Notice order ಆಗಿತ್ತು. Notice order ಆದ್ಮೇಲೆ
Next one ಬಂದ್ಬಿಟ್ಟು NOC ಕೊಡ್ತೇನೆ.
ಪೆಂಡಿಂಗ್ ಆಫೀಸ್ ಸಬ್ಸೆಕ್ಷನ್ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ಅವರು.
Without recalling. I am notice.
Why you have filed two sets of applications? It was dismissed only once. Thereafter,
Once.
notice was ordered.
By oversight, by, by oversight.
Really, we are.
Cash.
ಎಷ್ಟು ಹಾಕೋದು cost? 10,000 ರೂಪಾಯಿ ಕಾಸ್ಟ್ ಹಾಕ್ತೀವಿ.
Yes.
So casual.
ಈಗಲೂ ನಿಮಗೆ ಏನು ಅಂತ ಗೊತ್ತೇ ಇರೋದಿಲ್ಲ. You only make us to work. It
Please,
was not dismissed subsequently.
10,000 cost happens.
Sorry, my lord. Sorry, my lord. I will.
On examination of the reports, it is found that
Weeks time will be
the
granted.
appeal was dismissed on 19/8/2017.
For passing any order on the application. Let the appellant serve the copies of.
Copy serve ಮಾಡಲ್ಲ, ಅದಕ್ಕೆ ಕೊಡೋದಕ್ಕೂ ನಾವು you are seeing what is happening.
We will
Even in
supply
the
copy.
trials
Does not
courts,
know anything
even in the
clear.
court of junior civil judge, these things will not happen.
We
We are sorry to
supply
express.
copy.
It's not more.
Sorry. And you do not know why you have filed two sets of applications.
Earlier it was dismissed and later
You recall that
getting
I
filed
number
from
1 of 2022 and 2 of 2022 are filed. Again, the appellant's council has filed IA number 1 of 2023 and 2 of 2023, claiming that the appeal is dismissed on 14/11/2022. Whereas on 14/11/2022, only notice of IA 1 and 2 of 2022 was ordered.
None of the copies are seen on the rest.
Therefore, even the copies of those applications are not served on the other side since 2 years. The case is being conducted in a very callous manner. We will dismiss IA 2 and 1 and 2 of IA 1 and 2 of 2023 are dismissed, and finally 1 week time is granted to serve the copies on the other side and to comply the other pending office objections on payment of cost of rupees 10,000 payable to the High Court Legal Services Committee.
5,000. They are
Failing which the application, failing which IA 1 and 2 shall stand dismissed. This is nothing but abuse of the process of the court.
sorry, my lord, because we have taken the matter without.
See,
proper instructions.
A person performing certain functions is expected to have minimum level of competence.
Please, ma'am. Sorry, ma'am.
Next, number 5, Padma Suttur, Veerabhadra Swami H.
The respondent number 2 is passed away, my lord. We have filed the LR's application, same.
Respondent number 2 notice ಹೋಗಿತ್ತ ಅವ್ರಿಗೆ ವೀರಭದ್ರ ಸ್ವಾಮಿ ಯಾರು appearing
for response. Others, notice.
Carry out the amendment. I'll carry out the amendment, my lord. I'll file the amended petition by tomorrow.
ಯಾವಾಗ ಆಗಿದ್ದ ಆರ್ಡರ್
27/6/22, 27/9.
submit the amendment. This was on 27/9/2023. Order was passed on. ಅವಾಗ್ಲೇನೆ 2000 rupees ಕಾಸ್ಟ್ ಹಾಕಿದ್ದಾರೆ. 15/11/2022
My lord, earlier
has
some
filed
other.
memo for having deposited cost of rupees 2000. The said memo is taken on record. When this application was allowed, LR application, that was on 27/6/2022. 2 ವರ್ಷ ಒಂದು ಕಾಸ್ಟ್ ರೇಟ್
Here the advocate, the team was appearing, my lord. Subsequently, I came on.
ಯಾವಾಗ ಬಂದಿದ್ರಿ? when you came on record? ಪದ್ಮಾ
On 30th March.
ಪದ್ಮಾ
20.
ಉತ್ತೂರ್.
Yes, my lord. On 30th
Yes,
March,
sir. ನೀವು 2022 ನಲ್ಲೇ ಅಪಿಯರ್
my
ಆಗಿದ್ದೀರಿ.
lord, the file was not there, my lord. I traced all the files. I requested.
ಅಪ್ಲಿಕೇಶನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇರುತ್ತಾ? ಅದನ್ನ ನೋಡಿ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ತಗೊಂಡು
One day application.
That request finally 1 week time is granted to do the full
I'll
and
carry
payment of cost of rupees 5,000 payable to the High Court Legal Services Committee.
My lord, I'll carry out today itself, my lord.
See, unless we are like, do like this,
My lord,
we have to afternoon ವರ್ಗು ಬರೀ orders matters
No, the thing is, my lord, the file was not there, my lord.
Next.
For that reason, I filed.
We
number
have
6.
practiced, we know how to do
Yes,
it.
madam.
We can take the court file and do it. Yes, next.
Seal number 6,
Appeal for
Sunita H.
reference.
Singh.
Appellants, please, your lordship, the second set of the application has not been filed, your lordship. Those applications are ready.
Indian cases for 2 years, last year, it was not done. Therefore,
Application rejected.
non-compliance of office subsections raised on IA 1 of
Petition rejected.
67. Again, what is that office?
Second
Second
set.
of 2023 for condonation of delay. Second set file ಮಾಡಿ, no?
Oversight
A
has-
2 of 2023 for recalling the order dated 15/11/2022. Second set of IA to be filed. ಇದು ಯಾವಾಗ 2022ರಿಂದ
No,
not
Your
filed.
lordship,
Second set.
I have been subsequently come on record, please, your lordship. The
Is that
urgent-
an excuse? When did you come on record?
Your lordship, I have filed the wakalat on 21/2011, please, your lordship, 21.
21.
21/21.
21ರಿಂದ ಈಗ 4th year.
But then unfortunately, it so happened, your lordship, the file was misplaced. I couldn't trace that file. And when I had got to know about the matter, it was been dismissed for default. My name was not reflected, though I had filed a NOC wakalat before this honorable court. The earlier council name was reflected, and on that day, the appeal got dismissed for
And
default.
dismissed. That was only peremptory order. It's not
15/11/2022, please, your lordship.
15th November 2022.
Please, your
Even if
lordship.
your name is not shown.
No, please, your lordship.
You had not, why had you not complied it?
Your lordship, but I
After
was
your
not, aware-
appearance.
I had not got the file as well, your lordship. It's
Whether
a-
we have to come to your house to give the
No,
file
no,
to you?
I mean to say is the council who was earlier handling the matter had not handed over the entire file to me, and I was not aware as to what are the objections to be
Request
complied,
finally.
please.
1 week time is granted to do.
So lordship, the
No, no, will comply, the application dismissed as lodged in impose cost. What is this decree for application petition is dismissed or what is this? Dismissed finally. 1 week time is granted to do the needful, failing which needful on payment of cost of rupees
Ila Swami.
2,000 payable to the High Court Legal Service Committee, failing which IA 1 and 2 of 2023 shall stand dismissed.
Obliged.
Seal number 7, BM Kushalappa.
1 week's time may be granted. US council has been expanded, madam. Subsequently, I filed wakalat.
Yeah, one of CD in recalling.
Ah.
Where is the recalling application?
It's filed, madam. The previous council has filed in 6th April 2021.
What
But
is
he has not filed the application for condonation of delay.
ಗೊತ್ತಿಲ್ಲ ಉಲ್ಟಾ ಹೇಳ್ತಾನೆ.
You have the copy of that application?
Yes, madam. 6th April 2021, madam.
April 2000?
21, madam.
2017.
But another application for condemnation delay is not filed.
We are seeing is only your condonation of application.
It is not there, madam.
What
Only
makes
recall
it
application is
not
there.
6/4/2022.
ಸಿಡಿ ಇಲ್ಲ.
Where is the application for condonation?
It is not filed, madam. Hence the office has raised the objection. 1 week's time may be granted, madam.
ಇದು 2021 ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿರೋದು.
ಹೌದು.
LIC case ಆಗಿದೆ.
The council has been expired. Recently, I filed my Kalata.
When did you file the wakala?
I filed in the 19 December 2023, madam.
19th December 2023. You are from his office only?
No, madam. It's a CGC, madam. Central government. It's a railway matter.
Railway matter.
Oh.
We cannot, will have two standards. Deputy Chief Engineer. ಇನ್ನು ಕಾಪಿನೂ ಸರ್ವ್ ಆಗಿಲ್ಲ.
ಇಲ್ಲ.
ಸ್ಪೆಷಲ್ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಷನ್ ಅಟ್ ಲೀಸ್ಟ್ ಅವ್ರಿಗೆ ಆದ್ರೂ ಕೊಡ್ಬೋದಲ್ರಿ. Respondent to is state.
I'll serve the copy. Serve the copy.
6 years. Whether they have filed execution.
Not yet, madam. Because one more matter is there, madam. It is it's pending MFA 9764 of 2017, madam. So,
Arising out of same award?
same, two LSA has been clubbed and judgment has been passed.
Same award.
Same award.
Same judgment. Huh? Correct. Connected ಇದೆ ಅಂತಾರೆ ಅದ್ರಲ್ಲಿ whether this respondent number 1 is party in that case also.
No, madam. The respondent one is the different party.
But request finally 1 week time is granted to do the enactment. Compliance of what is that office objection?
That CD, the delay application has to be filed.
Three no file ಆಗಿದೆ. Request finally 1 week time is granted to do the enactment, failing which I 1/21 shall stand as this.
Public.
Number 8, Chetan B, HCGP.
Connected ಅಲ್ಲ ಇವಾಗ ಬೇರೆ ಅಲ್ಲ parties are different. Non filing of memo for having served the copy.
Copy served.
Served
ಮಾಡಿದ್ರೆ I pray for 1 week time to file a statement.
Furnishing of the.
ಇಲ್ಲ,
Yeah.
only one respondent, my lordship. That is the
Statement of objections. to-
special land acquisition officer, only one respondent, my lordship.
Only one respondent.
Please, my lord.
Yes, we'll see.
Objection,
Special and, oh, this is a claimant's appeal.
please.
Issued. Leonard ACA submits that he has received the copies. Therefore, office objection regarding service of complaint. Since he has taken notice, respondent, the office objections regarding process fee, etc. Overruled. Okay. You want to file objections. How much delay is there?
1,246 days, my lordship. 46 days.
What reason ಹೇಳಿದ್ದೀರಿ? What reason ಹೇಳಿದ್ದೀರಿ?
Please.
LIC number 478.
Lack of knowledge towards them. Preferring a fulfilled in time.
ಯಾವಾಗ ನಿಮ್ಗೆ ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿರೋದು? ಯಾವಾಗ ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ? When have you served the copies on you?
Recently they have served the copy. ಅದು 2/1/2024 ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಸರ್ವ್.
Ill health, lack of knowledge, in preferring the appeal. English ನಲ್ಲಿ signature ಮಾಡಿದ್ದಾರೆ. Lack of knowledge. After engaging the co-claimant in LIC number 469 of 2014, I was under the impression that appeal is filed for enhancement of the compensation. Who is the co-claimant? ಒಬ್ರೇ ಇಲ್ವಾ ಇರೋದು claimant?
ಅಲ್ಲ, ಬೇರೆ ಕೇಸಲ್ಲಿ LIC
ವಿಠಲ್ ಏನ್ ಹೇಳಿದ್ದಾರೆ ನೋಡಿ. Correct, but he was not co-claimant. That was an independent case. ಅವ್ರಿಗೆ ಯಾಕೆ ಇಂಟ್ರೆಸ್ಟ್ ಮಾಡ್ತಾರೆ ಇವರು?
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಬ್ಯಾಚ್ ಮ್ಯಾಟರ್ಗಳಾಗಿವೆ ಸ್ವಾಮಿ.
ಕರೆಕ್ಟ್. ಈಗ ಕಾಮನ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದ್ರೆ ಬೇರೆ, ಕಾಮನ್ ಪಾರ್ಟಿ ಇದ್ರೆ. That was a different case and this is a different case. Is only the trial court has consolidated all the matters and passed ಕಾಮನ್ ಜಡ್ಜ್ಮೆಂಟ್. ಎಸ್ ಏನು ಕಾಸ್ಟ್ ಏನಾದ್ರು ಹಾಕಿ ಮಾಡ್ಬೋದಾ ಹೇಗೆ? Interest. Hey, we will deny interest and we are not very satisfied about this explanation. We are finding this kind of practice only in land acquisition cases. ಇಲ್ಲ ಮತ್ತೆ ಅದರಲ್ಲೇ ಇರುತ್ತೆ ಇರುತ್ತೆ. Delay is ಎಷ್ಟು? 1,246 days. ಬೇರೆ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ಇದಾವ ಇದರಲ್ಲಿ? Which are those matters?
My lordship, 10456, 10457, 10458.
Appearing in those matters. You are appearing in those matters.
Please, sir, we are not fair, please.
ಅವು ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಅಡ್ಮಿಟ್ ಆಗಿದೆಯಾ?
My lordship, one matter for 10456, 11th ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ ಇವು ಕಾವೇರಿ ನೀರು ನಿಗಮಕ್ಕೆ ಪಾರ್ಟಿ ಮಾಡಿದೀವಿ, ಇಂಪ್ಲೀಡ್ ಮಾಡಿದೀವಿ. ಅವ್ರಿಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ ಅಂತ ಹೇಳಿದೀನಿ.
Considering the reasons assigned to explain the delay.
Connected numbers.
The reasons assigned for explaining the delay. Not very satisfactory. Since the land loser's right is involved. Right is involved. The delay of 1,246 days in filing the appeal is condoned in the interest of justice. Subject to payment of cost of rupees 5,000 payable to the High Court Legal Services Committee. ಅದು ಗೊತ್ತಾಗಬೇಕು ಸ್ವಲ್ಪ ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಬರೀ ದುಡ್ಡು ಎನಿಸ್ಕೊಳ್ಳೋದು ಆಮೇಲೆ ಹೆಚ್ಚು ಮಾಡಿ ಅಂತ ಆಗ್ಬಾರ್ದು. ದೇ ಆರ್ ಟೇಕಿಂಗ್ ಎವ್ರಿಥಿಂಗ್ ಫಾರ್ ಗ್ರಾಂಟೆಡ್. ಕೊಡಿಸಿ ಅಡ್ವೊಕೇಟ್ಸ್ ಹತ್ರನೇ ಕೊಡಿಸಿ. You are seeing what every day in day out we are seeing only these things only in the land acquisition cases. Muda case we are generously condoning. One latest Supreme Court judgment is that it should not be condoned. In the other case, latest judgment. Payment of this 5,000 payable to the state respondent. Is a state or other statutory body, no?
State.
Beneficiary are really acquisition officer nobody party madidare. It was for which project? Beneficiary are the acquisition. If it is enhanced again, they will come up saying that they were not heard.
Yedichi reservoir project.
ಅದು ಯಾರಿಗೆ ಬರುತ್ತೆ? ಮೈನರ್ ಇರಿಗೇಷನ್ ಅವ್ರಿಗೆ ಬರುತ್ತೆ.
Minor irrigation.
ಅಥವಾ ಅದೇನು ಡಿಫರೆಂಟ್
Minor irrigation.
ಈ ಕೇಸಲ್ಲಿ ಹಾಕೊಂಡಿಲ್ಲ. ಇದ್ರ ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡಲ್ಲ, ಮಾಡೋದೇ ಬೇಡ. We don't pass any order on this. If that is the case, we'll see in which case you have filed including application.
10456 of 18, my lord.
It is submitted. ಅಲ್ಲಿ ನೀವು ಬೆನಿಫಿಷಿಯರಿ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕಲ್ಲ. Then when you file execution case, they will come up in appeal. ಆರ್ ಇದನ್ನ ರಿವ್ಯೂ ಕೇಳ್ಕೊಂಡು ಬರ್ತಾರೆ. Submitted that this matter is connected to MF number 7 server protocol. List both on the matters together on 11th, that is 11/6. Number
File
9.
application in this also. Meantime, you file
See,
application.
Please.
Beneficiary is somebody else. If they have to pay the award amount, you have to make them also a party.
Till number 9, Giridhar H.
ಓದೋದಿಲ್ಲ, ಬರೀ ಚೆಕ್ ಬರೋದು ಮುಂದೆ ನೋಡ್ತಾರೆ.
Sole respondent is dead, my lord. Even though your lordship had directed to complete the LRs in the last date itself, that is a year back, my lord. Now we have traced out the LR information of the LRs. I'll file my necessary application in a week, my lord.
9/6/2023
Please, please, ma'am.
ಆಗಿದೆ, ಬೇಕಾದ್ರೆ ಅಪ್ಲಿಕೇಶನ್
Please.
Pick up the respondent case. Postal endorsement ನಲ್ಲಿ ಬಂದಿದ್ದಲ್ಲ.
Please, ma'am.
On 9/6/2023. Order dated 9/6/2023.
Please.
అది ఎది అమౌంట్ ఉంది రాదు పోస్టల్ ఎండార్స్మెంట్ 5/11/22 అంతే. The sole respondent is reported by postal endorsement dated B11/2022. 2022.
It's all right.
Therefore, the appeal already stood debated. No further answer. Yes.
I do, please.
If you file necessary application, then.
Please, my lord. Oblige.
Cell number 10, R. Gopal, Ramakant Rao.
Weeks accommodation, my lord. Do the needful.
Next.
We have filed an IA for.
IA for additional documents, IA for index to be stated correctly. When have you filed this?
Yeah, 22, 20.
41, 1/2024.
Please.
Appeal or.
Copy is ready, my lord. We'll serve the other side. Copy is ready. We'll serve on the other side.
Who is appearing for that? ಅದಲ್ಲ ಇದ್ರಲ್ಲೇನೋ annexures ಎಲ್ಲ ಹಾಕ್ಬೇಕು ಅಂತ ಇದೆ ಅಲ್ಲ.
Weeks accommodation, my lord.
ಹಿಂದೆ ಫೆಬ್ರವರಿಯಲ್ಲಿ ಪ್ರಭಾಕರ್ ಶಾಸ್ತ್ರಿ ಇರ್ತಾರೆ. ಅದಕ್ಕಿಂತ ಮೊದಲೇ ನೋಡಿಲ್ಲ. ಅದಕ್ಕೊಂದು ಇಂಡೆಕ್ಸು ಮಾಡಿಲ್ಲಲ್ರಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋದಕ್ಕಿಲ್ಲ.
You produce one.
What is this? They have rounded it. Satisfies finally 1 week time is granted to the victim, failing which A 1/2023 shall stand dismissed.
Cell number 11. Prashant.
I appear for the appellant, my lord. I'm extremely sorry. I will comply with the office objection by next 2 days. It's an early hearing application which had been filed. There is a mistake on my part. I'll comply by 2 days.
What is this? What is IA 1/2023?
Early hearing also.
ಅದಕ್ಕೆ ಒಂದು ಹೋಗುತ್ತೇನ. Otherwise, it was being listed in the
I'm
regular final
sorry.
hearing matter.
I'm
Because
sorry.
of application, it is being delayed. Finally, 1 week time is granted to the victim, failing which IA 1/2023 shall stand dismissed. Yes.
Number 12,
Okay.
MM Ashoka, AD Vijaya.
For the appellant, my lord. The matter is settled before mediation.
Parties are present.
Parties are not present.
ಮತ್ತೆ ರೆಕಾರ್ಡ್ ಮಾಡಬೇಕಂದ್ರೆ parties ಬೇಕು.
Maybe posted on 7th. We'll keep the party.
Oh, PS for
Respondent AD Vijaya.
Not present.
She also has to keep her party present.
ಏನ್ ಸೆಟಲ್ಮೆಂಟ್ ಏನಾಗಿದೆ ಅಂತ.
Settlement, the appeal was filed against the decree of divorce passed by the trial court, my lord. And there were multiple litigations for there, all matters are settled now.
There was custody matter also.
The child,
There was custody issue also.
the child, it was here, the appellant was granted visitation right with respect to the minor daughter. Now, there was a partition
First
who,
defendant agreed to cooperate to withdraw and quash the following cases.
yes, ma'am.
1, 2, 3, 4 cases.
Yes, madam.
There was a partition suit was there.
These are still not withdrawn.
Now, the main was the partition suit, my lord, where the both the petition appellant and respondent, they purchased jointly a property. And now the respondent herein, she has executed release deed. It is already executed, my lord.
One of the condition is parties will appear before the High Court for passing the orders in terms of this.
Yes, my lord, a date may be given. It has,
No representation for the rest.
next week.
Counsel for the appellant seeks time to keep the parties present to record the memorandum of settlement list out. 7th you want?
Allah, next week.
Next. Yeah, parties have to.
Again, any day.
The date of
11th.
11th.
Yes.
ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ
Inform ಮಾಡ್ತೇವೆ.
Cell number 13, P. Narasimhan.
Appearing for the appellant, my lord.
Connected matrimony case here is shown as MC 833 of 2019 instead of MC 833 of 2018. ಅದಕ್ಕೇನಾದ್ರೂ ಮಾಡಿದ್ದಾರಾ? ಅದು ಅವ್ರ ಮಿಸ್ಟೇಕ್ ಅಲ್ವಲ್ಲ. ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ತಗೊಳ್ಳಿ ಆಫೀಸ್ ಆಫ್ ಸೆಕ್ಷನ್. In this you have to take steps.
My lord, counsel Ajay Prabhu can take notice for the respondent, my lord, because it is a connected matter.
Ajay Prabhu, he is appearing in the connected matter, but he is not there. No? If he is there, we could have directed him to take notice. If he agrees. Yenidu matter.
I'll take instructions.
There were two MC cases. One was by her, other was.
13 main case, restriction.
One was petitioner in MC number 671 has filed section 13(1)(1)(a). Separate husband filed for divorce. Petitioner has filed section 9. So her application is about his application is dismissed. ಅವ್ರಿಗೆ ನೋಟಿಸ್ ತಗೊಳ್ತೀರಾ ಅಂತ ಹೇಳಿ ಫಸ್ಟ್ ಶ್ರೀ ಅಜಯ್ ಪ್ರಭು ನನ್ನ ಕೌನ್ಸಿಲ್ ಹೂ ರೆಪ್ರೆಸೆಂಟ್ಸ್ ಅಲ್ಲ ಇದರಲ್ಲಿ ಅಪೂರ್ವ ಚೈತ್ರ ಅಂತ ಇದೆ ಮೊದಲನೇ ಮ್ಯಾಟ್ರಲ್ಲಿ. ಎರಡನೇದ್ರಲ್ಲಿ ಚೈತ್ರ HV ಅಂತ ಇದೆ. ಯಾಕೆ ಅವ್ರ ಕಾಸ್ಟ್ ರೈಟ್ ಅಲ್ಲಿ ಹೇಗೆ ಹಾಕಿದ್ರು ಹಾಗೆ ಮಾಡಿದ್ದಾರೆ. ಬಟ್ ಪಾರ್ಟೀಸ್ ಆರ್ ಸೇಮ್ ಅಲ್ವಾ?
Same parties.
Wife of daughter of Venkatesh Gowda. Wife of so and so and daughter of so and so. Literally daughter of so and so. Shri Ajay Prabhu M. Counsel who represents the respondent in the connected matter is requested to accept notice for the said respondent. Appellant's counsel shall serve the copies on him. You serve the copies on him. Registry shall show his name in the copies for the respondent. List up to 1 week. Connected matter ಅಲ್ಲಿ ಹೆಸರು ತೋರಿಸಿ ತಪ್ಪಿದೆ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. 833 of 2019 ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಡಿಕ್ರಿಯಲ್ಲಿ decree, it is decree, in the decree it is correctly mentioned. Yes, connected matter. In the impugned judgment, in the cost title of the impugned judgment, ಎಲ್ಲದರಲ್ಲೂ ಹಾಗೆ ಇಲ್ಲ. In the cost title, the year of the MC petition number is wrongly shown, but the same is correctly shown in the other pages of the judgment and the decree. And the petitioner appellant is not responsible for that. Therefore, office objections overruled. ಅದರಲ್ಲಿ ಏನಾಗಬೇಕು, ಕನೆಕ್ಟೆಡ್ ಕೇಸಲ್ಲಿ ಅಡ್ಮಿಟ್ ಆಗ್ಬೇಕಾದ್ರೆ ಮತ್ತೆ ಅಡ್ಮಿಟ್ ಆದ್ಮೇಲೆ ನಮ್ಮವ್ರ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡಿದಾರ. ರೆಕಾರ್ಡ್ಸ್ ಅಡ್ಮಿಟ್ ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ ಫರ್ ಆಗಿದೆಯಾ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ?
PCR ಕಾಲ್ ಆಗಿದೆ.
ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದೀವಿ ಸರ್ ಮಾಡ್ತಾರೆ. ಹೆಂಗಿದ್ರು ಒಂದೇನು ರೆಕಾರ್ಡ್ ಕಾಲ್ ಫರ್ ಆಗಿದೆ. Yes, Dr. Vanna.
Cell number 14, R. Shashidhara.
1 week time may be granted.
Steps to be.
Necessary application will file for us.
Should,
Paper publication.
Third time, second time unclaimed.
Third time,
1,413 days. we learn.
ex parte judgment, my lord.
My request finally 2 weeks time is granted to do the review. In which practice shall stand dismissed. Yes.
Cell number 15.
15, I appearing for the
Favor of CM.
appellant, my lord, finally weeks time. You corrected us 3 times ತಗೊಂಡಿದ್ದಾರೆ ಜಾರಿ ಆಗಿಲ್ಲ.
Third time, no?
Please.
My request finally 2 weeks time is granted to do the review. Failing which practice shall stand.
Cell number 16, C. Babu.
Appellate counsel, madam, as per the postal endorsement, respondent number 1 was that, madam. 3 weeks time may be granted, madam. I filed my,
When that postal endorsement has come? R1.
please, sir. R1 is there.
There are other claimants also.
Illa, sir, other respondents,
Whole claimant.
two to,
State.
4 are state government, sir.
ಯಾವಾಗ ಬಂದಿದೆ ಅದು ಎಂಡಾಸ್ಮೆಂಟ್ 2022 ಬಂದಿದೆ ಅಂತಲ್ರಿ ಎಂಡಾಸ್ಮೆಂಟ್
As a
ಡೆತ್ ಆಫ್
beneficiary appeal, the railway is filed on a, please, ma'am.
we record the appointment, other two will be there, you file the application if you want.
Please, ma'am.
ಅವ್ರ ಮೇಲೆ ಸರ್ವೈವ್ ಆಗೋದಿಲ್ವಲ್ಲ ಅಪೀಲ್ if it you should take in a reasonable time. 2 ವರ್ಷ ಆಗಿದೆ ಅಲ್ಲ ಈಗ.
Yes, ma'am. ಅದು ನಮಗೆ before, after filing up the portal Sharam only, I came to know that.
ಅದು 2022 ನಲ್ಲಿ ಬಂದಿದೆ.
ಹೌದು. ಇಲ್ಲ, subsequently,
ಕೊಡಿ ಅಂತ. ನೋಡಿ 2000
on 10/10/2022, notice has been issued. After that, 10/10/22 was issued. Notice issue ಆದ್ಮೇಲೆ, this is the first time matter listed before this honorable.
No, not first time list ಆಗಿಲ್ಲ. 10/10/2022 ನಲ್ಲಿ ಒಂದ್ಸರಿ ಲಿಸ್ಟ್ ಆಗಿತ್ತು.
ಹೌದು ಸ್ವಾಮಿ, 10/10/22.
Issue emergency notice to the respondents. ಅದಾದ್ಮೇಲೆ ಈಗ ಬಂದಿದೆ. Finally 2 weeks time is granted to the.
Has not served the copy.
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ.
ಮಾಡ್ತೀವಿ ಸ್ವಾಮಿ, ಅಲ್ಲ ಪೋಸ್ಟಲ್ ಸರ್ವ್ ಆಗಿದೆ. Once again, I'll serve the copy.
Every house.
Serve to all respondents, serve ಆಗಿದೆ ಸ್ವಾಮಿ.
Service ಆಗಿದೆ ಎಲ್ಲರಿಗೂ. They are served and represented. Then we can't direct them to give notice. You can request and take notice. Or notice ತಗೊಳಕ್ಕೆ ನಾನು ಡೈರೆಕ್ಷನ್ ಕೊಡಲ್ವಾ ಈಗ? ನಿಮ್ಮ ಆಫೀಸ್ ಅವರು ಹಾಗೆ ಮಾಡ್ತಾರಲ್ಲ, ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್, ಇನ್ನೊಬ್ಬರು ಚೀಫ್ ಸೆಕ್ರೆಟರಿ ರೆವಿನ್ಯೂ ಡಿಪಾರ್ಟ್ಮೆಂಟ್.
Please, your honor.
If they do not respect the summons, then
Land acquisition officer, deputy chief commissioner.
NLC accepts notice for response 2 to 4. ಅದಾದ್ಮೇಲೆ at request 2 weeks time is granted to the.
Hearing on AS, cell number 70. B. Satish Sundar. Jaikar Shetty.
May it please, Lord. Lord, first of all, my apologies, Lord, for not being present on 16/6/2023 when the matter was taken up. I filed an IA to recall the order of dismissal and for hearing the appeal on merits. I apologize, Lord, I was not present on 16/6 when the matter was taken up. I was unwell. Therefore, I filed an IA now to.
Jaikar Shetty, you represent. What do you say for this recalling application?
This is a penalty.
Oh, the penalty, they have not even deposited the penalty amount. That's what they have observed.
Lord, I will tell you, Lord, because this is an appeal under section 54 of the FERA against the order of the tribunal. The appeal was admitted.
This against first authority was filed in 1995.
Yes, 1995.
Appellate authority
The adjudication
was
was
filed
in the.
in 2014.
Correct. Lord, it was heard number of times. I'm sorry to say this, but it was heard number of times by your lordship's predecessor's bench in a number of times, but unfortunately, Lord, for want of records from the other side, Lord, the case was adjourned from time to time. In fact, to make things easier, I have filed a small short synopsis and submissions along with case laws. I'll be ready with the main appeal itself anytime which your lordship says.
Where do we find that this matter was heard several times? Can you tell us
Lord,
the
it was,
dates?
Lord, it was before Justice Patel's bench, my Lord, it was heard. Number of times it was heard.
Can you
You're all.
Altered ಆಗಿತ್ತು sir. Not release ಮಾಡಲಿಲ್ಲ ಅದು. ಅರ್ಧ ಕೇಳಿ ಇದ್ದದ್ದು. ಯಾಕೆ what happened in the respondents, 3 counsels was the panel advocacy has changed. So that is very difficult for the enforcement actors in Delhi. So that they have not could not appear for that ಅಂತ ಹೇಳಿ respondents 3 advocates ಗಳು change ಆದಾಗ ಅದು ಸ್ವಲ್ಪ inconvenience ಆಗಿ we have to drag on the matter. We are ready, but respondent advocate we are not, government was nominated by the panel advocate. ಅದು ತುಂಬಾ ವರ್ಷಗಳು ಹೇಳಿದ್ರು.
Initially,
Earlier,
Mr. Mahesh.
Mahesh is there. Mahesh.
1 minute, Prasad, I'll address. Initially, Mr.
Yes, please, sorry.
Mahesh was appearing for the respondent. Lord, a number of panel councils have changed.
Is it mandatory to deposit the penalty amount while filing?
No,
the
it is not. It is not.
Section
It is not.
50.
It is not. 54 will not do. It's only on a question of law. It is only on a question of law arising out of the tribunal's order. Lord, it is not like Customs Act, where there is a requirement of pre-deposit in the tribunal stage.
From any decision and order of appellate court.
In fact, at the tribunal stage, my Lord, in section 19, when the appeal was filed, the appeal itself was taken up for final disposal without a pre-deposit. An order was passed to that effect. This is an appeal under section 54 of the FERA.
55
Against
of the
the-
Foreign Exchange Management.
No, Foreign Exchange Regulation Act, earlier act.
No, your appeal is under section 54 of the FERA Act
Yes.
and under section 35 of the Foreign Exchange Management Act.
Because 35 was
1999.
Is it?
correct. Because by the time the appeal was taken up, my Lord, the Foreign Exchange Management Act had come into force. Now, my Lord, the appeal has to be
That
dealt
will
with. Appeal will have to be dealt with only under
just
section.
a minute, we'll see what that section says.
Yes.
Section 35.
Yes, 35. Lord, I have 35. Can I read 35, my Lord?
Yes, please read it.
Any person aggrieved by any decision or order of the appellate tribunal may file an appeal to High Court within 60 days from the date of communication of the decision or order of the appellate tribunal on any question of law arising out of such order, provided the High Court may, if it is satisfied that the appellant was prevented by sufficient cause from filing the appeal within the said period, allow it to be filed. So it is on a question of law against the decision or order of the appellate tribunal. And your Lordship will also have a look at section 54 of the Foreign Exchange Regulation Act, which is also similarly worded.
We saw that.
Yes. Kindly take section 54, my Lord.
What was the amount of penalty imposed?
Lord, amount of penalty which has been
By the
imposed,
first-
yes, by the first appellate authority, my Lord, is to the extent of,
That is at page number.
yes, 20 lakhs. 20 lakhs in total.
Page.
Lord, page number, yes. In the paper book, my Lord, your Lordship will straight away
That
go
is
to
a
the order.
substantial question of law that
Lord,
was formulated while admitting the appeal.
Lord, substantial question of law is
When the appeal was.
the entire case of the
No,
department is,
admitted. What is that formulated?
Lord,
Yaವಾಗ admitted? When it was admitted?
Lord, it was
When the
admitted.
appeal was admitted? 1/1/16.
I have also formulated the question of law. Kindly see the grounds of appeal for a minute.
No substantial question of law is formulated at the time of admitting the appeal.
Lord, then it has to be formulated and then it has to be heard. Because your Lordship knows it is only on a question of law we have to agitate.
Appeal admitted. That's all it is said. But this section says 54 as well as 35 say that appeal has to be admitted on a substantial question of law.
Precisely, Lord. Precisely. I have formulated
while
certain
dismissing
questions
this-
of law. I have formulated certain questions of law. Basically, my Lord, what I am wanting to project before this honorable court is that the entire case is based on the retracted
So in
confession of the
section
appellant.
35 that was not there.
Lord,
Section 35 did not contemplate a substantial question of law.
it does. Kindly have a look at section 35.
Any person aggrieved by the decision of appellate tribunal, etc.
Yes.
On a
May
question
file
of law arising out
on
of
any question of law
such
arising
order.
out of such order. Yes.
Here,
Because this is a second appeal, your lordship very well knows. Even though it's called a miscellaneous first appeal before the High Court, it is a second appeal because against the adjudication order, I go to the Appellate Tribunal for Foreign Exchange, which is at New Delhi. Against that, my lord, I come to this court.
Actually, it should have been MSCA, my lord. Miscellaneous second appeal. By mistake, I think it has become
No, no.
MFA.
I don't know whether there is an MSA in Karnataka, but miscellaneous first appeal is what it says.
only on the question of law, and even in the amended provision, it is like that only.
Yes.
Correct. From 2014 till this day, none of you have said that there is a substantial question of law involved. And had you mentioned in your appeal memo?
Yes.
Question of law, all right, question of law, not substantial. In your appeal memo, you have mentioned that what is the
Yes.
question of? Oh,
Yes,
he has
my lord.
mentioned.
At page 12, internal page 12.
ABCD.
Is internal page 12.
It is as good this. Yeah. Then here, but in a dispose not goes and guys.
One date may be fixed, my lord. Ultimately, it
lordship
is an old matter. But last occasion, lordship observed, my lord,
So where is the provision? It says
penalty amount has not been.
you submitted that they have not paid the penalty. We have discussed.
Please.
Is there any provision in under the acts saying that it's a precondition for deposit of
No,
amount
no.
is precondition?
In fact, my lord,
No, no.
rule
In
10, rule 10, my lord.
One minute.
Rule 10 of,
Sir, I'll make my submission. Your lordship will kindly see, my lord, section.
He has
50.
raised that point. Learned counsel, he has raised that point. We are asking him, where is the provision making precondition?
Yes,
Even now
I'll
also
make.
we can direct them to deposit the amount if law requires that.
Law doesn't require.
Rule 10.
Rule 10 of 1973 Act or
Even 2000 rule, my lord.
2000.
The latest FEMA. Now it is FEMA after 99.
Management, adjudication and proceedings rules 2000. Correct?
Please. Internal page 39, my lord.
Which rule is that?
Correct. FEMA Act. FEMA Act says.
Yeah, correct. Rule Rule 10.
Rule 10 of that 2000 rules.
Exchange management regulations.
No. Appeal and adjudication.
Adjudication and proceedings and appeal. Ali internal page 39 irbo running of the book, my lord. 39.
Nimdu namdu one day publication, na?
Normally.
Then seem to be like that.
But if I may intervene for a minute.
All right.
Form of appeal. Rule 10 form of.
Rule 10 is. Yes, Bodhi.
Every appeal presented to the appellate tribunal.
Appellate tribunal.
That is there, my lord, appeal. So here also appeal. The appeal shall be in a triplicate accompanied by 3 copies of the appeal against 10,000 form of in cash and demand draft payable in favor, so and so on. Provided that applicant shall deposit the amount of penalty imposed by the adjudicating or the special director, as the case may be, such authority as may be notified under the first proviso to section 19 of the Act. Provided further that, where in a particular case, the appellate tribunal is of the opinion that the deposit of such penalty would cause undue hardship to such person, the appellate tribunal may dispense with such deposit subject to such conditions as may deem fit to impose so as to safeguard the realization of penalty. No doubt here, my lord, before tribunal it is mentioned.
Correct. Whether in the tribunal they have dispensed with that. They are deposited before the tribunal, this amount?
Lord, they have not deposited, Lord. The appellate tribunal granted full waiver of the penalty amount and took up the main appeal itself for disposal.
Whether this section rule of 10 applies to the appellate tribunal appeals.
Yes, you only
word
apply to
used
the
there,
appellate.
But High Court appeal.
Because
High
they
Court,
suffer
there is
2
no
orders.
condition.
Right. Rule 10 applies. You could have insisted whether they have. Are you aware whether they have deposited or not deposited?
He says, no, it is dispensed with, like he submits like that. Because we are
No,
not say about this second appeal before the High.
Maybe
And
it may
second
be heard
appeal,
finally, but anyhow, we are in 2024.
Is it a point advocated?
Lord, there is no provision for deposit
We
before
have
the High
seen.
Court.
So now both of you have to submit what is the question of law involved in the case.
Lord, I am already
We
formulated.
say there
in
is
my
no
grounds.
question.
No
I have
question of-
formulated in my grounds. My grounds may be kindly taken.
You have to satisfy us that those questions are really involved in the case.
Yes,
Mr. Jayakar Shetty, whether formulating those questions can be set down for final hearing, or you want to argue on that?
Lord, Lord, I will suggest one thing.
Years is over, my lord.
Now, may I
We
suggest
shall
may I suggest one thing?
get ready for hearing, my lord.
I will sit with my friend. We will formulate the grounds, the grounds on which the grounds of appeal, the substantial question of law, and place it before your lordships for your lordship's consideration. That will be
Correct,
better.
we have formulated about 5 or 6 questions of law. Do
Yes,
you say
question
that
of.
all these are really questions of law, or any of only some of them are the real questions of law?
Lord, I think all are questions of law, according to me. Because what has happened, Lord, I'll tell you, lordships, what has happened.
But
Lord,
none
the
of them
entire,
refers to any particular provision of the act. None of these questions which are formulated.
yes,
All are question of fact.
And
Lord,
yes,
according
one
to
is about
him.
reflection, one is about confession, relying on the confession statement. Whether under the law there is any bar under the specific law in relying in some of the cases like TADA Act, the court can rely on the confessional statements. Like
No,
in
no.
AP.
Lord, that is why, my Lord, I placed case
But
laws together.
in the evidence, my lord, they have admitted it, my lord. It's a question of fact, my lord, appreciated by both the finding.
Lord, that is why, my Lord, I placed all the case laws.
Now he has formulated a question saying that the tribunal was in error in relying on the confessional statements, and it has not taken into consideration the retraction statements. Whether under this particular law, is there any provision to rely on this confessional statement? Whether confessional statements are admissible?
Lord, if I may say so, it is something like Customs Section 108 of the Customs Act. Here, the statements are recorded in terms of Section 39 and 40 of the FERA. They are admissible, but whether they are acceptable or not has to be determined by the authority. Now, 2 authorities have decided against me. I am saying before this court that the lower authority, that the appellate tribunal as the lower authority, ought to have taken the retraction and the confession together and then made an exercise to find out whether it is acceptable or not. That is one of the blood.
So you agree that there is under that act those confession are admissible?
No, they may be admissible, but acceptability is different. Admissible is one thing, acceptability is one thing. So therefore, my submission may not. Malad, may I make a suggestion? Lord, my friend is contending that these do not give rise to a question of law. I am saying it gives rise to a question of law. Let us debate it in the final disposal. Lord, I have also filed a synopsis and submissions, which your lordship will have, my lord, dated 28/3/2016.
So according to you, even now, this A and B become the questions of law, not
Yes, A and B.
other questions.
Yes, yes.
A and B. So we'll
Yes,
calculate only those 2 questions. All right?
yes, right. Very good. And your lordship has to hear me on that.
Yes.
Lord, I will convince your lordship
But you
that
have not, because your duty at the time of admission to say that court has to formulate these substantial questions.
we formulate it. Ultimately, it is for the court to decide. In fact, the court itself will not at that point of time felt that the entire appeal can be heard because all the.
So you took advantage of this for 10 years?
Lord, I am not taking 10
about 10 years.
I want to finish off the case. My endeavor is to finish the case.
I have one of question. I have one of accepting the reasons. Yeah, ground, why, what is that ground you have urged? In IA 1 of 2023.
But I was not well, my lord, I could not be present. I was supposed to appear on that day. I was not well, I was down with fever. Therefore, I made a request to my colleague, Mr. Prasad, to take an adjournment.
16/6/2026. Now it is 1 year, that order is passed about 1 year, right?
I understand, my lord, that is why I am ready for the disposal of the main appeal itself. If your lordship so fixes a date, or if lordship
So
may
this
think,
application hearing itself again took 1 year time.
I'll move them several times, memo.
Correct.
Bench is not, so that is shuffle, so that you have to.
ಇಲ್ಲ ಮೊದಲು ಆಫೀಸ್ ಆಫ್ ಸೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಮಾಡಿರೋದಿಲ್ಲ ನೀವು ಒಂದು 6 ತಿಂಗಳು
Yes.
ಐಎ ಮೇಲಿಂದ ವಿಲ್ ಇಂಪೋಸ್ ಸಮ್ ಕಾಸ್ಟ್
No, there is no any office objections.
There's no office of
No. Nothing is there. Only I move the memo, but bench is not sitting the shuffle. That is a very difficult. And then and last occasion, so move the memo before vacation.
in fact, at one point of time, your lordship was also sitting in the other bench in Dharwad.
And the appeal is restored to the file in the interest of justice. So, an appeal under section, it is noticed that the appeal of the present kind file lies only on the questions of law. However, while admitting the appeal on 1/12/2016, the questions of law were not formulated. On hearing both sides, it is ordered that the appeal shall be heard on the following questions of law.
But I had also pressed on C, my lord, A, B, C. A, B, and C, my lord. C is
You
also
have
very
made
important.
2B. Yeah. Learned counsel, in B only you have made two questions. Again, there also, in your appeal memo,
C is also there.
C.
C nu ಎರಡು ಮಾಡಿದಾರ ಇಲ್ಲ.
ಅಲ್ಲ ಇದೆ. Corporated.
He only say that is where the corroboration is required.
There is, because there is a retraction.
Corroboration is required.
Not-
Sorry, one A and B. ಅದು following questions ಅವರು A, B and B ಅನ್ನೋದನ್ನ ಎರಡು ಮಾಡಿದ್ದಾರೆ. 1, 2, 3 ಮಾಡಿ. Okay. English for final hearing on.
Lord, will your lordship will not give a date in June itself?
13th. 13/6. 12/6. 12. 12/6. 12/6.
Not 14th, my lord. I have some 14th.
Criminal matter. ಇದು
14.
criminal matter. Actually, this is also a criminal matter only.
Please.
14.
14.
Not 14th.
Much obliged.
14th. Grateful to
Much
the lords.
Till number 18, KB Loknath, AGA for R1, Sharat Chandra for R2.
KB Loknath is given the NOC. Lord, KB Loknath has given a NOC.
This is the IA 1, 2,447 days given. Setting aside the abatement, bringing the loss of deceased applicant. Yes,
NOC ಕೊಟ್ಟಿದ್ದು.
NOC ಕೊಟ್ಟಿದ್ರೆ you have given NOC.
Yes.
ಗೊತ್ತಿಲ್ಲ ನೀವು you should retire or you should conduct the case. We are not aware of all these NOC and we can't take notice of that. 2,447 days delay is there. What is the reason assigned? Who is appearing at the house? AZ. ಏನ್ ಹೇಳಿದ್ರು? ನೀವು ಲೋಕನಾಥ್ ಅಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
I will file a retirement memo.
You are not Loknath. Are you Loknath?
No, I am my colleague.
Then ಬಿಡಿ. We'll take. How, if your colleague is on record, how can you give NOC?
I will inform him.
ನಾವು ಮಾಡ್ತೀವಿ ಬಿಡಿ. 2,447 ದಿವಸ ಡಿಲೇ ಇದೆ. ವೀರಮ್ಮ 94 years. Her in-laws were on record ಅಲ್ವಾ? In-laws of deceased. I mean,
Loknath has given NOC.
copies to be served. Other side copies. But these applications are not disposed of. Then why they have amended the appeal memo? Taking aside the abatement and Court of Siri pending ಇದಾವ application ಯಾಕಂದ್ರೆ ಅವ್ರ appeal memo amend ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. These are filed of course in 2024. ಈ amendment to 2020 ಗೆ amend ಮಾಡಿದ್ದಾರೆ.
Brilliant on that.
ನಿಮ್ಮ appeal memoದಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ. 2020 ಗೆ ಅಂತ amendment. Order sheet ನೋಡಿ 2020 ಅಥವಾ 2020.
As per order 99 ಅಂತ ಹೇಳಿದ್ದಾರೆ. 9918.
ಅವಾಗ ಯಾರು A to E ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಈಗ that is LR application. ಓ ಇದರಲ್ಲಿ appellant on record. Appeal? LR's 1/15.
ನೀವು notice ಕೊಟ್ಟಿದ್ದಾರೆ.
Oh,
ಇಲ್ಲ, ಅವಕಾಶ ಕೊಡಿ.
additional documents. Affidavit ಈರಮ್ಮ ಅನ್ನೋರ್ದೇ ಇದೆ ಅವಾಗ. In 2015. Why did you amend the appeal memo without bringing the LRs on record?
I don't know.
1 of 2015 was a delay condonation application. ಅವಾಗ appeal file ಮಾಡೋದ್ರಲ್ಲೂ 1531 days delay was there. And at that time 2020 no 2020 list ಆಗಿತ್ತ ಕೇಸ್. ಅವಾಗ ಒಂದು application ಒಂದು set of application ಹಾಕೊಂಡು seeking enhancement, seeking condonation and setting aside the abatement and leave to bring on record the LRs. ಈಗ ಪುನಃ ಅದೇ ಪಾರ್ಟಿನ A B C D E ಸೇಮ್ ವೀರೇಶಪ್ಪ ಇದು ಎಂತದ್ರಿ ಎರಡೆರಡು ಸರಿ 2018 ನಲ್ಲಿ ಅಲೋ ಆಗಿರೋ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಗೆ ಮತ್ತೆ ಹಾಕೊಡ್ತೀರಿ ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್.
Number 2 to 5 ಅಂತ ಹೇಳ್ತಾರೆ.
ಅದೇ ಇನ್ನೊಂದ್ಸರಿ ಹೇಳೋದು ಬರೀ ನಾವೇ ನೋಡ್ಬೇಕು ಎಲ್ಲಾ ರೆಕಾರ್ಡ್ಸ್ ದೇ ಡು ನಾಟ್ ಅಸಿಸ್ಟ್. ಡೇಟ್ ಹೇಳಿದ್ರು 2018 19/9/2008. ಇದೇನೋ ಒಂದ್ಸರಿ ಡಿಸ್ಮಿಸ್ ಆಗಿತ್ತು ಅಂತ ಕಾಣಿಸುತ್ತೆ.
ಈರಮ್ಮ is died in Bhutan.
ಡಿಸ್ಮಿಸ್ ಎಕ್ಸ್ಪೈರಿ
ಅದು ರಿಸ್ಟೋರ್ ಆಯ್ತು. ಆಮೇಲೆ ರಿಸ್ಟೋರ್ ಆಯ್ತು.
ಅದು ಡೇಟ್ 19/9/2008. IA 1 of 2018, 2 of 2018, 3 of 2018 are filed. So condemnation of delay, setting aside abatement. ನೋಡಿ ಇದ್ರಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಇದೆ. ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ತೀವಿ ಚೆಕ್ ಮಾಡ್ಲಿ ಹಿಂದೊಮ್ಮೆ ಅಲ್ಲ.
ಮತ್ತೆ ನಾನು ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ರೆ
These applications are filed by one Sangesh Patil. But here he is not there on record. Sangesh Patil is not there on record. ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ ಚೆಕ್ ಮಾಡಿ ಒಂದ್ಸರಿ ನೋಡಿದ್ರೆ
ನೋಡಿ ಸ್ವಲ್ಪ ನೀವು ನೋಡ್ಕೊಂಡು ನೋಡಿ ಯಾರು ಉಪಯೋಗ ಇಲ್ಲ.
ಯಾಕಂದ್ರೆ ಅದು ಕರೆಕ್ಷನ್ ಮಾಡಿಟ್ಟಿದೀವಲ್ಲ ಅಲ್ಲಿ those applications were allowed.
Number 90, PD Surana.
My lord, appearing for the on behalf of the respondent counsel. Counsel is not well, my lord. Kindly 1 week.
Really, the additional ground that is sought to be raised is that there is a, while notifying the acquisition proceedings, 17 guntas of land which were already acquired by the railway is also notified. Now that notification is quashed by this honorable court in WP. That the writ petition copy I filed along with the application.
Subsequent event.
Subsequent event. Kindly take my application IA number 1. IA number 1,
1/2022.
yes. Adರಲ್ಲಿ I have produced the certificate, I have produced the copy of the order made by the Honorable Court in WP 13,697.
This has attained finality.
Yes,
Production document
the acquisition to the extent of 17 guntas is quashed.
belonging to this claimant only.
So the compensation has to be reduced by 17 guntas. And thereafter, for the neighboring land, this Honorable Court has remanded back the matter by in MFA. That I am raising additional grounds. So both the application may be allowed.
Only subsequent event of that.
Lord, he has been hospitalized from yesterday. Mainly 1 week, my lord.
But these applications also can be heard along with the main matter.
Let the matter be fixed for hearing along with that.
These applications, because
Agod.
additional evidence and.
Very well, very well.
IA 2/2022. No, 1/2022. ಅದಾಗ್ಲೇ 1/2022 considered along with the main matter ಅಂತ ಆಗ್ಲೇ ಆಗಿದೆ.
The amendment of the grounds ಒಂದು ಹಾಕಿದ್ದೀನಿ. That amendment of the grounds may be allowed. Or the amended, the grounds can be taken note of at the final hearing also. Additional grounds can be taken note of at the final
If
hearing.
that comes into question, if your additional evidence is accepted, right?
That is, what is one aspect. The neighboring land was acquired and award was made. This Honorable Court in MFA has remanded back the
You
matter.
can consider that
Very well,
2016
very well.
matter.
Obliged.
The proposed amendment arises out of the documents produced under IA 1/2022. IA 1/2022 is referred for consideration along with the main matter. This application also shall be heard along with the main matter. I list the matter for final hearing on 24/6. 24/6. Old matter date ಆಗ್ತಾ ಹೋಗುತ್ತೆ. Old matter. 19/6. 19/6.
Number 20.
Great.
Gas Shakamba.
Here for the appellant, my lord. I request.
For final hearing, my lord.
Final.
Yes.
I request this honorable court to adjourn the matter by 2 weeks. Court fee ಬಂದ್ ಕಟ್ಬೇಕು. ನಾನು ಎಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದೀನಿ. ಅವ್ರ ಹತ್ರ ಏನೋ ದುಡ್ಡು ಇಲ್ವಂತ.
2017 matter.
ಇಲ್ಲ ಅದೇನಾಯ್ತು ಅಂದ್ರೆ 17 ಅಲ್ಲಿ ಅಪೀಲ್ ಕರೆಕ್ಟ್ ಟೈಮ್ ಹಾಕಿದ್ದೀನಿ. 2019 ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು. ಸಿಂಗಲ್ ಜಡ್ಜ್ ಮುಂದೆ ಇತ್ತದು. ಆಮೇಲೆ 1 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ ಪರ್ ಗುಂಟೆಗೆ ಅಂತ ಗೊತ್ತಾಯ್ತು. ಡಿವಿಷನ್ ಬೆಂಚ್ಗೆ ಬಂತು. ಸಿಂಗಲ್ ಜಡ್ಜ್ ಮುಂದೆ ರಿಕಾಲಿಂಗ್ ಹಾಕಿ ಆಫೀಸ್ಗೆ ಹೋಗಿ ಎಷ್ಟು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ರು ಅವ್ರು ಪೋಸ್ಟ್ ಮಾಡ್ಲಿಲ್ಲ. ಮೂವ್ ಮಾಡಿದ್ರು ಪೋಸ್ಟ್ ಮಾಡ್ಲಿಲ್ಲ. ಆಮೇಲೆ ಏನಾಯ್ತು ಎನ್ಹಾನ್ಸ್ ಡಿವಿಷನ್ ಬೆಂಚ್
ಕೊಡೋದಕ್ಕೆ ಏನ್ ತೊಂದ್ರೆ ಇತ್ತು ನೀವು?
ಅವ್ರ ಹತ್ರ ದುಡ್ಡು ಲಕ್ಷಾಂತರ ರೂಪಾಯಿ.
ಇಲ್ಲ ಅಂದ್ರೆ ನಮ್ ಲೀಗಲ್ ಸರ್ವಿಸ್ ಅಥಾರಿಟಿ ಕಳ್ಸಿದ್ರೆ ಮಾಡ್ತಾರೆ.
ಹಂಗ
ಕೊಡಕ್ಕಾಗ್ಲಿಲ್ಲ.
ಐ ವಿಲ್ ಅಡ್ವೈಸ್ 15 ಗುಂಟೆ ಇದೆ.
They want to have a cake and eat it too.
ಪ್ಲೀಸ್ ಮೇಲಡ್.
They want to have a cake and eat it too.
ಅಲ್ಲ ಇವ್ರದೇ ಲ್ಯಾಂಡ್ ಅಕ್ವೈರ್ ಆಗಿ ಅದಕ್ಕೆ
But for if you keep it pending for 8 years, why the interest shall be paid out of the public money?
ಅಲ್ಲ ಇಂಟ್ರೆಸ್ಟ್ ವೇವ್ ಮಾಡ್ಬೋದು.
ಅಷ್ಟೇ ರೀಸೆಂಟ್ಲಿ ನಿನ್ನೆ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ತೋರಿಸಿದ್ರು ನಮ್ಗೆ.
ಪ್ಲೀಸ್
ಮಿಸ್ಟರ್ ವಿವೇಕಾನಂದ, Supreme Court in a latest judgment has held that mechanically that cannot be done. Payment of the comply the pending office objections, failing which I 1/2023 shall.
2 weeks ಕೊಟ್ಬಿಡಿ. ಅಷ್ಟೊಳಗೆ ಮಾಡದೆ ಹೋದ್ರೆ ಐ ಡೋಂಟ್ ಆಸ್ಕ್ ಎನಿ ಮೋರ್ ಟೈಮ್. ನಾವು ಯಾಕೆ ಹಿಂಗ ಆಗ್ತಾ ಇದೆ ಅಂದ್ರೆ ಮೈ ಅನುಭವ 20,000 ಕೊಟ್ಟಿರ್ತಾರೆ. ಅದು ಜಾಸ್ತಿ ಅಂತ ನಾವ್ ಅಷ್ಟ್ ಕೇಳೋಷ್ಟೊತ್ತಿಗೆ 1 ಲಕ್ಷ ಇನ್ನೊಂದ್ ಕೇಸಲ್ಲಿ ಕೊಟ್ಟಿರ್ತಾರೆ. ಆಸೆ ಅಲ್ಲ, ಈಗ ಪಕ್ಕದ ಮನೆಗ ಪಕ್ಕದ ಲ್ಯಾಂಡಿಗೆ ಅಷ್ಟು ಕೊಟ್ಬಿಟ್ಟು.
You claimed 40,000 merely because the neighbor got 1 lakh. Why should you
similarly situated
if you are capable
constitutional
you should do that.
ಅಲ್ಲ ಅದಕ್ಕೆ ಕೇಳಿದ್ರು. ಪ್ಲೀಸ್ ನಮ್ ಎನಿ ಹೌ ದಿ ಮ್ಯಾಟರ್ ಇಸ್
Number 21. Ramurthy BB, RV Sadashivappa.
As of today, I have paid entire amount, madam. Except this month, that is May. May month, my lord.
May month they have to make payment.
As requested by both sides, finally based on 4/6/2022. If renewal is not done before that time, consequences shall follow and the matter has to be heard on merits. What is that?
But I have filed IA.
That order was recalled, my lord.
9150. It's number ಎಷ್ಟು? Appeal number. Serial number ಎಷ್ಟು?
Number 20.
They are all separate proceedings. Oh, by family court. 70,000 and 1,62,000.
No, I make one submission. IA 2/2018, my lord. I have filed the application for seeking direct him to pay the arrears of maintenance. Now he has paid the entire amount.
Entire
up to
amount.
April 2024. Therefore, so IA 2/18, I am not that application, my lord. IA 2/18 may kindly be dismissed or disposed.
Then what about these memos?
Memos, they have to make, they have to file, they have not filed. Acclement, we have received the amount.
If you.
We have received the acclement.
Received, then
Yes,
that does
no,
not.
not necessary, ma'am.
IA 2 of 2018.
2 of 18 may kindly be dismissed for direction.
So many applications.
Only 4 applications are pending, my lord.
4 applications.
Only 4, my lord.
One for 2024.
3 application filed by me, 1 application filed by the other side. 2/18 may kindly be dismissed.
1 minute.
2/18 for direct the appellant to pay the arrears of maintenance of rupees 1,08,000.
ಎಲ್ಲ slip ಹಾಕಿರ್ತಾರೆ, ಸಿಗೋದಿಲ್ಲ. 1 of 2018 is section 24
Yes,
application.
1 of 2018 is section 20.
24 ಹಾಕೋ ಬದಲು 25 ಹಾಕಿದ್ರೆ ಎಲ್ಲಾನು ಡಿಸೈಡ್ ಮಾಡ್ಬಿಡ್ಬಹುದು. ಮೇನ್ ಮ್ಯಾಟರ್ ಡಿಸೈಡ್.
ಅಲ್ಲ 25 ಹಾಕ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ, ಯಾಕೆಂದ್ರೆ ನಮ್ಗೆ ಗಂಡ ಬೇಕು ಅಂತ. We want my husband, my lord. Therefore, you are not filed application on section 25.
I have filed the divorce.
I don't want any permanent alimony. I want my husband. Therefore, I have not filed application.
Pay the arrears of 1,08,000.
That application may dismiss, my lord. 2/18. I am not pressed.
The appellant has paid arrears of entire
Yeah,
arrears.
I have received.
Entire,
Yeah, received.
please.
Entire arrears.
Entire.
To April 2024.
24.
May kindly be noted.
The arrears of maintenance.
Up to April
which was
2024.
Up to April
24.
2020.
Yes.
Yes.
Therefore, the IA ಮತ್ತೆ the
2/18 may kindly.
IA 2 of 2018 is not pressed.
Not pressed. That's
But IA number.
ಅವಾಗ ಇದೆಲ್ಲ ಹೋಗ್ಬಿಡುತ್ತಲ್ಲ ಮೆಮೋಸ್.
ಅಲ್ಲ
Yeah,
ಮೆಮೋ
please, madam.
ಅವೆಲ್ಲ ಹೋಗ್ಬಿಡುತ್ತೆ.
All-
Yes. ಅವ್ರ ಅಕ್ಲಮೆಂಟ್ ಹಾಕಿಲ್ಲ, ಅದನ್ನೆಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡಬಹುದು.
Does not survive for further consideration. IA 2 of 2018 and office subsections regarding the non-filing of the acknowledgement
Acclamants.
for paying the dues do not survive for consideration and disposed of accordingly.
Yes.
ಈಗ IA
IA 1/18.
1 of 2022 seeking educational.
Yes, my lord. I have spent 4 lakhs.
1 of
towards-
2024 in.
They have filed for seeking stay of the proceedings in this.
How that can be done here?
My lord, there's a, the respondent has filed the maintenance petition before the family court.
That is already
Yes.
paid.
Yeah.
ಅದಕ್ಕೆ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
Stay ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಈ ಕೇಸಲ್ಲಿ. This is only pendency of the proceedings I have sought for maintenance, section 24.
So this arrears they have paid, that included that
Yeah,
125.
definitely, my lord. Definitely.
Arrears.
So IA 1/24 will not serve.
IA 1/24, my lord. This is right, kindly.
Oh,
My lord,
address on IA 1 of 2024.
24.
Under this part, under this application.
my lord, that they have filed a application, they have filed a criminal miscellaneous under section 125 before the family court, wherein they sought for the permanent alimony.
No, only for maintenance.
125.
Permanent.
Permanent alimony ಕೇಳಿಲ್ಲ.
125 ಓದಿದೀರಾ? Section 125.
Killer lifetime.
Maintenance, man.
Yes.
My lord, I have paid this amount, the entire arrears.
Correct. You go and
that can be
submit
adjusted.
Before the executing court.
Yes.
Is
That,
it a-
that amount will be adjusted, man, definitely.
Is it the recovery proceeding?
No. Only for maintenance.
125 only.
Only 125, maintenance.
If at all that is determined, future, only
Yes.
future amount will be determined.
That's all, my lord. That's all.
The appellant is seeking stay of
Further
further
proceedings.
proceedings in criminal miscellaneous number 437 of 2023. Pending on the file of the 4th additional principal judge family court Bangalore. This appeal is preferred by the husband challenging the dismissal of his petition for divorce
Yes,
on the ground of cruelty and
and digestion both.
desertion. Uh, Respondent, 2023 I'll file.
Yes,
this, huh?
23 years.
This appeal was dismissed on 8/11/2022, my lord.
As fine.
8/11/2022, the appeal was dismissed, my lord. They have not filed the application within 1 year, even one year also. They have, therefore, they have not,
Appeal was not.
appeal was dismissed, my lord. When
Dismissed
the
for default.
Appeal was dismissed for default. That time I have filed this CMS proceedings before the family court. In the-
For the respondent submits that since the appellant did not pay the ಇಲ್ಲಿ ಇಂಟ್ರಿ ಮೇಂಟೆನೆನ್ಸ್ ಅವಾರ್ಡ್ ಆಗಿತ್ತಾ?
ಇಲ್ಲ ಇಲ್ಲ
ಅಲ್ಲ ಅರಿಯರ್ಸ್
ಅಲ್ಲಿ 9,000 ಅರಿಯರ್ಸ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿತ್ತು 2012 ಅಲ್ಲಿ ಅದನ್ನೇ
ಅಲ್ಲಿ
ಕಂಟಿನ್ಯೂ ಮಾಡಿ
ಇಂಟ್ರಿ ಆರ್ಡರ್ ಆಗಿತ್ತು.
ಇಂಟ್ರಿ ಮೇಂಟೆನೆನ್ಸ್ ಸೆಕ್ಷನ್ 24 ಆಫ್ ಹಿಂದೂ ಮ್ಯಾರೇಜ್ ಆಕ್ಟ್ ಅಪ್ಲಿಕೇಶನ್ ವಾಸ್ ಅಲೌಡ್ ಬೈ ದಿ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್
24.
earlier.
Yes.
That was paid by him.
Appellant did not pay the interim alimony awarded by the trial court and failed to pay the maintenance for the children.
Yes,
She filed,
CMS.
respond filed criminal misdemeanor number 437 of 2023 seeking maintenance under section 125 of the CRPC. The appellant seeks stay of the said proceedings on the ground that now he has cleared the arrears of interim alimony awarded by the trial court.
Yes, under section 24 of Hindu marriage.
Interim alimony and
Yes, that's it.
Section 24 of the Hindu Marriage Act and section 125 CRPC are independent proceedings. If interim alimony awarded is paid, that may cover the claim of the wife in criminal misdemeanor number 437 of 2023. However, that does not claim whether in awarding 24 children's
Yeah,
that
one
was
level.
also considered.
Yes,
Children's need was also considered.
3,000 was awarded to the minor daughter, my lord. 6,000 was awarded. Section 24 of Hindu marriage act, ordered. Whatever the amount paid by him, that means that has to be adjusted in the.
If the appellant has paid the maintenance awarded, the interim alimony granted by the trial court, he can urge the same in
CMS.
criminal misdemeanor 437 of 2023.
Yes,
But no interim stay can be granted in the said case.
yes,
Therefore, the application is rejected.
rejected. And the next, my lord, IA 1/18 and IA 1/22, two application were pending, my lord. IA 1/18 filed by me, my lord. I have sought for 50,000 towards
Press
maintenance.
for time, sir.
First time,
Press time.
ನೀವು ಮಾಡ್ಬೋದಲ್ವಾ 125 ನಲ್ಲಿ ಅಲ್ಲೇನು
ಅಲ್ಲ,
ಹೋಗಬಹುದಲ್ಲ
ಇದು-
interim maintenance.
ಅದು
Why this matter should be pending for such a long time?
ಲಾಂಗ್ ಟೈಮ್ ಅಂದ್ರೆ ಇದು ಡಿಸ್ಮಿಸ್ ಫಾರ್ ಡಿಫಾಲ್ಟ್ ಆಗಿತ್ತು 2022 ನಲ್ಲಿ. Now restored, madam.
Merit ಇಲ್ಲ ಅಂದ್ರೆ we'll dispose of this matter.
Yes, kindly post it for final argument itself.
These
Yes.
applications, we will give you liberty to claim this in interim maintenance in 125
ಅಲ್ಲ,
proceedings.
section 125 proceedings filed by me in their 2023, my lord. I have sought for interim maintenance 2017 from the date of appeal to 2023, my lord.
ಅಲ್ಲ ಈಗ ನೀವು
Education expense 4 lakhs, I have already spent, my lord.
already spent.
Yes, there. And I have produced the documents also. Let him pay education expenses.
IA,
1/22, education expenses. I have furnished the documents also.
what is IA 1 of 2018?
18 is seeking maintenance of rupees 50,000. In this case, appeal ಅಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ 1/18. ಅದಲ್ಲಿ ಆತ ಮ್ಯಾನೇಜರ್ ಆಗಿ ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
And IA 1 of 2022. ಎರಡೇ ಅಲ್ವಾ ಉಳಿಯೋದು?
ಎರಡೇ ಉಳಿಯೋದು ಸ್ವಾಮಿ, ಎರಡೇ ಉಳಿಯೋದು. IA 1/22, IA 1/18.
See that IA
1/18 and IA 1/22.
IA 1 of 18 and 1 of 2022.
Yes, ಎರಡು ಅಪ್ಲಿಕೇಶನ್ ಉಳಿಯುತ್ತೆ.
Main matter.
Yes,
Appeal not admitted ಅಂತ ಇದೆ.
ಹೌದು, ಅಪೀಲ್ ಇವತ್ತವರೆಗೂ ಅಡ್ಮಿಟ್ ಆಗಿಲ್ಲ.
Of the year 2017. Records ಬಂದಿದೆಯಾ?
ಬಂದಿದೆ.
ಬಂದಿದೆಯಾ?
ಬಂದಿಲ್ಲ, ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ಲ. ಆಯ್ತು. Call for the records, please.
Admit 2011 case ಅದು.
ಹೌದು.
Admit call for TCRs. Sorry, telephonic requisition ಇದು ಬೆಂಗಳೂರು ಇದೆ ಅಲ್ವಾ?
ಹೌದು, ಬೆಂಗಳೂರು. ಇಲ್ಲಿ 4th additional family court, ಬೆಂಗಳೂರು.
Registry shall secure the TCRs expeditiously and telephonic requisition. Please for final hearing on 24/6.
Yes. ಯಾವತ್ತು? Final order.
Till number 22, Narsimurthy GV, HCGP for R1, Prashant PR for R2.
For respondent number. Two. Statement, objection. Objection.
In respect of the survey number 46, extent of 24 guntas of the land acquired for the LT Reservoir project. My lord. The 401 notification issued on 5/2/2009. The SLO is only grant of total compensation of 53.
Delaying in reason. Delay condone ಮಾಡಿದ್ರೆ then
My lordship, in the similar set of
not
fact,
aware of the court procedure and rules. One of my relative suggested and discussed with me after suggestion of my relative contacted the lower court advocate. Applied for the certified copies. Idrali award amount draw ಮಾಡಿದ್ರ ಇಲ್ಲೋ before this appeal filing the appeal.
My lord, it is drawn.
He examined that because he says he doesn't know the court proceedings. If they have withdrawn the amount, that shows whether they were aware of the court proceedings or not.
my lordship, in the similar set of fact, my lord, the delays days of is no interest to.
That does not become the precedent for us, right? You have said you were not aware of the court procedure. We'll see whether you have withdrawn the amount in deposit or not.
Lord, as per the instructions, my lord, they have withdrawn the amount for this.
Can you put me deposit and record?
Please.
Consider this application, whether it is bona fide or not bona fide.
Please.
In these two appeals, there is a delay of 1,281 days. 1,281 days in filing the appeal. The appellant's contend that they were not aware of the court procedure. Therefore, there was a delay. Learned counsel for respond number 2 and 3 shall submit whether you have not preferred any appeal.
We have not preferred.
Whether the appellants withdrew the amount, award amount deposited by respondents before filing this appeal.
Please.
Is wrong?
Weeks time.
Is wrong? 12/6. ಸ್ವಲ್ಪ ಎಲ್ಲ ಕೇಸ್ಗಳಲ್ಲಿ ಎಕ್ಸರ್ಸೈಸ್ ಮಾಡಿ ನೀವು.
ಮಾಡ್ತೇವೆ ಏನಂತೆ?
Number 23 adjourned, number 24.
12/6.
C. Shankar Reddy, Ravindra MB.
Filed an application for substituted service.
ಏನಂತ ರಿಟರ್ನ್ ಬಂದಿದೆ? Notice respond number 4. That represented before the trial court.
Respondent number 4 was not represented. Not is the
Respondent number 4
husband
is
of the first
Venkatesh.
respondent. Is the husband of the first respondent and father of respondents 2 and 3.
No, what was his rank before the trial court? Respondent number 1. Respondent number. Oh.
He was respondent to.
Representing him in before the trial court?
No, my lord.
ಅಲ್ಲಿ ಮತ್ತೆ ಶಂಕರ್ ರೆಡ್ಡಿ ಅಂತಾನೆ ತೋರಿಸಿದಾರಲ್ಲ FDP. This.
My lord, the FDP, I was for the respondent number 3.
Purchaser ಮಿಸ್ಟೇಕ್ ಆಗ ಎಲ್ಲದಕ್ಕೂ 1 to 3 ಶಂಕರ್ ರೆಡ್ಡಿ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್.
I was only for respondent number 3.
By Shri Shankar Reddy ಅಂತ ತೋರಿಸಿ. He had not appeared.
He has not appeared. Not he is the husband of the third respondent and father of respondents 1 and 2 in the present appeal.
You were respondent number 3 in the
I was
case.
respondent. I am the purchaser. All the others are family members.
Easy Venkatesh. ಅದು KL Venkatesh.
Please.
Are you going to accept notice for him?
Please, madam.
He is your family member, whether you are going to appear for him. Respond number 4.
No, he is the against my lad. Without our consent.
Sold the
The,
Please.
the children and the wife filed a suit for partition before the family court, stating that the fourth respondent before this court has sold the property in my favor against their wishes. Sale deed is challenged.
Correct. What happened? What happened in the suit?
Suit has been decreed,
Read.
and an observation has been made that as far as possible, the purchaser share should be accommodated in the my vendor share,
Of the
in the
vendor.
vendor share. And in the FDP proceedings, that was not done. The present appeal, my lord, is against the FDP proceedings.
So
Where
you say that he is sailing with them and they say that he is sailing with you.
Please.
Okay. Time for records ಅಲ್ಲಿ ನೋಡ್ಬೋದು ನೋಡಿ 1 to 3 is ಎಲ್ಲಿ ಬೆಂಗಳೂರೇನಾ is residing in ಅವ್ರ ಅಡ್ರೆಸ್ ಏನಂತ ತೋರಿಸಿದೀರಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಪಾದರಾಯನಪಾಳ್ಯ ಪಾದರಾಯನಪುರ ಬೆಂಗಳೂರು
ಕೆಂಗೇರಿ ಹೋಗ್ರಿ
Convent.
ಏನಂತ ಬಂದಿದೆ ಮೊದಲು ಕಳ್ಸಿದ ನೋಟಿಸ್ left without instructions. Orders and I want to notice. Satisfied that respond number 4 is reading the notice and service of notice on him in the ordinary course is not probable in the near future. Therefore, appellant is permitted to take notice to him by paper publication as prayed for. The notice shall be published on or before 26/6. 26/6 big notifying the hearing date on
10/7.
10.
Please.
Okay.
I number 1 of 2023 is disposed.
Number 25, R. Ramchandran, K. Ramchandran, R. Shashidhara, for R1.
For the appellant, my lord. My lord, we have deposited 50%, my lord, in this case, but I could not produce the document. They have it day after tomorrow, 7th, my lord.
Are you aware? Deposit money.
Listen, we are not.
Two times is the direction.
You already deposited, my lord.
Correct. You should, you are a statutory authority, you should produce it.
Day after
We'll give liberty to them if not deposited to.
Day after tomorrow, I will produce the document.
Now, constitutional
7th.
appellant submit that the appellant has deposited 08 deposited delay of 139 days is there.
Please, ma'am.
Already interim order ಕೊಟ್ಟಿದ್ದೀವಿ.
Also,
Deposited amount in compliance of the order dated ಯಾವತ್ತು 14/8/2020.
14/8.
14/7 and 14/8 ಎರಡು ಇದೆ ಅಲ್ಲ
14/7 ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ.
50%. ಮತ್ತೆ 14/8 ಏನು?
ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಬೇಕು ಅಂತ.
14/7/2023. However, no proof is produced. If the amount is not deposited, the respondent or claimant is at liberty to execute the award.
On
You
7th,
we have passed a conditional order. If it is not deposited, they are at liberty.
on 7th, I will produce the document. Kindly have it on 7th, my lord. Delay may be condoned for this. Please.
We will not condone
No,
it
no,
unless you do
on
it
7th as well. No, no issue.
as requested list on 10/6. 10/6.
11/6, my lord.
11/6.
Please.
11/6, seal number 26 adjourned, seal number 27, maybe Sidramaya.
Appellant for appellant, my lords, in this case, there is a delay in paying PF, my lord. 58 days, conditional order was passed to pay PF. And we have not noticed the conditional order, my lord, hence the extension of the PF I have filed. Meanwhile, the appeal was dismissed for delay in paying PF.
This was passed on 17th February
Yes, I
2020.
have paid PF on 16/5/2023.
You have paid it now.
Paid it, but delay in paying the PF. After expiry of the time granted by this, we have paid.
Note ಮಾಡಿದ್ದಾರೆ ಅಂತ. No, office has not noted that.
No, I have the acknowledgement. My lord, on 16/5 I have
ಅದು
filed.
very- ಇಲ್ಲ,
Since it is dismissed, notice has not been sent.
ಇಲ್ಲ, ಇದ್ರಲ್ಲಿ
ಇಲ್ಲ, ಇಲ್ಲ.
deposit
I have the acknowledgement.
generally ಬರೀತಾರೆ ಅವರು.
ಕೊಡಿ.
Paid after the order as well. Now counsel for the appellant submits that he has paid the, he has
Yeah, on
compared the
16/5/2023.
on 16,
5/2023.
16/5/2023.
During that time was already expired.
Verify and submit. If needful is not done, the same shall be complied within 1 week, failing which I number 1 and 2 of 2023 shall stand dismissed. Now verify ಮಾಡೋದಕ್ಕೆ ಹೇಳಿದೀವಿ. ಮಾಡಿರ್ಲಿಲ್ಲ ಅಂದ್ರೆ 1 week ಅಲ್ಲಿ whatever office objection is there, you should comply. Otherwise, these applications will be rejected.
Cell number 28 adjourned. Cell number 29. A. Nagarajappa, H. N. Basuraju.
ಅದಕ್ಕೆ 10 days ಮಾಡಿ. ಯಾಕಂದ್ರೆ ಫೈಲ್ ಹೋಗೋದಕ್ಕೆ 10 days 1 week.
Lords, kindly, 28 concern mentioned. In fact, in that matter, I had some urgency of seeking an order directing the respond number 3 not to late. ಯಾವ date ಅಂತ ಗೊತ್ತಲ್ಲ, ಒಂದು ಶಾರ್ಟ್ ಆದ್ರೆ 28.
To file counter, ಹಾ.
I am for the appellant number 3, my lords. Please. Regarding adjournment, I will not come in the way. Let it be little short because they are trying to alienate the property, my
10
lord.
days. 10 days ಕೊಡಿ.
Mostly move ಮಾಡಿ ತಗೊಂಡಿರ್ಬೋದು, ಅದ್ರ ನಂದೇನು ಅಭ್ಯಂತರ ಇಲ್ಲ.
Pleading application is filed
by the appellant number 3 to implead the respondent number 3, my lords, please.
ಆಯ್ತು 10 days.
Purchase the short date ಕೊಟ್ಟು because
ಕರ್ಕೊಂಡು ಬನ್ನಿ ಹಾಗಿದ್ರೆ.
ಆಯ್ತು.
Yes, cell number 29.
Notice has to go on the application for impleading,
Yeah, 1/2024.
please.
To implead whom?
My lord. One Rajiv Gandhi, one Raj,
ಯಾರಾದ್ರೂ ಪೆನಲ್ ಅಡ್ವೊಕೇಟ್ಸ್
ನಾಗರಾಜಪ್ಪ ಏನೋ ಬೇರೆ ಇರ್ತಾರಲ್ಲ, ಇವ್ರು
ಇದ್ರೆ ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿ.
ಇಲ್ಲಿ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್
ನಾಗಯ್ಯ ಬೇರೆ ಇರ್ತಾರೆ. ನಾಗಯ್ಯ.
ರಾಜೀವ್ ಗಾಂಧಿ ರೂರಲ್ ಹೌಸಿಂಗ್ ಕಾರ್ಪೊರೇಷನ್. ಯಾರು ನೀವಿದ್ದೀರಾ? ಯಾರು?
Rajiv Gandhi, rural housing,
ನೀವಲ್ಲ?
rural housing corporation,
ನಾಗಯ್ಯ ಅಂತ ಯಾರೋ.
please, I will,
ನಾವು ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ ಸೈಮಲ್ಟೇನಿಯಸ್ಲಿ ಬೇಕಾದ್ರೆ ಸರ್.
please, ma'am, please.
ಬೆಂಗಳೂರೇ ಅಲ್ವಾ? ಇಶ್ಯೂ ನೋಟಿಸ್ ಆಫ್ 1/2024 to the proposed respondent. ಎಷ್ಟಾಗ್ತಾರೆ ಅವರು? ರ್ಯಾಂಕ್ ಬರ್ದಿಲ್ಲ.
Respond number 4, respond number 4 ಅಂತ.
ನೀವು ಬರೀ ಪರ್ಟಿಕ್ಯುಲರ್ಸ್ ರೆಸ್ಪಾಂಡ್ ಅದನ್ನ ಬರೋದ್ ಏನೋ ವೈಟ್ನರ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀರಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಅಂತ ಅಷ್ಟೇ. ಇದೆಯಾ ನೋಡಿ ನಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ನೋಡಿ, ಅವ್ರು ಯಾವ ರ್ಯಾಂಕ್ ಅಂತ ಏನು ಬರ್ದಿಲ್ಲ. ರಾತ್ರಿ ಹಾಕ್ಬೇಕು. ಬರೆದು ವೈಟ್ನರ್ ಹಾಕಿದ್ದಾರೆ, ನಿಮ್ಮದ್ರಲ್ಲಿ ಹಂಗೆ ಇದೆ. ಅಡಿಷನಲ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಟ್ಲೀಸ್ಟ್ ಈಗಾದ್ರೂ ಕರೆಕ್ಟ್ ಮಾಡಿ ಅದನ್ನ. Proposed respondent number 3 ಅಂತ ಬರ್ಕೊಳ್ಳಿ. Simultaneously, counsel for the appellant is permitted to serve the notice on Shri Nagayya. Standing counsel, standing counsel for respondent. ಅಂದ್ರೆ ಹೆಸರು ಹೇಳಿದ್ರೆ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಲ್ಲ ಅವ್ರ ಹೆಸರು, ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಅವ್ರ ಹೆಸರು ತೋರ್ಸಕ್ಕೆ ಸ್ವಲ್ಪ ವೆರಿಫೈ ಮಾಡ್ಕೊಂಡು ಬಂದು ಅವ್ರ ಹೆಸರು ಹೇಳಿ ಅಂದ್ರೆ ಅದು ಬರಿತೀವಿ ಆರ್ಡರ್ ನಲ್ಲಿ. ಅವ್ರ ಹೆಸರು ತೋರ್ಸೋದಕ್ಕೆ
ಅಂದ್ರೆ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಅಂತ ಬರೀರಿ, ನಾನು ಮೆಮೋದಲ್ಲಿ ಹೆಸರು ಬರ್ಬಿಟ್ಟೆ ಹಾಕ್ತೀನಿ ಅಕ್ಲೈನ್ಮೆಂಟ್.
ಅಲ್ಲ ಅವ್ರ ಹೆಸರು ಕಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ತೋರ್ಸಕ್ಕೂ ಹೇಳ್ತೀವಿ ನೆಕ್ಸ್ಟ್ ಟೈಮ್. ಅದಕ್ಕೆ
ಆಯ್ತು, ನಾನು ಕೇಳ್ಕೊಂಬಂದು ಹೇಳ್ಬಿಡ್ತೀನಿ.
ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ registration show his name in the cause list for the proposed respondent number 3. List down later. ಅದನ್ನ ಕರೆಕ್ಷನ್ ಮಾಡ್ಕೊಳ್ಳಿ
ಈಗಲೇ ಮಾಡಿ.
26/6. For admission, cell number 30. T. Shankar Reddy, Shruti C. Chaganti.
For respondent in this case, madam, I pray for a pass over, madam, kindly. Senior. Kindly pass for the
records call for modern biಡಿ.
Madam, have it at 2:30, madam, kindly, madam. Senior wants to argue the matter.
2:30 we have one fixed matter which is fixed where Senior counsels are appearing from other states.
Kindly, my lord, or else tomorrow, my lord.
ಆಗ್ಬೋದಾ? ನಾಳೆ ಅಂತ. ಈಗ ಎಲ್ಲ contrast ಇದೆ.
Like, my lord,
Correct.
probate has been taken.
ಆಯ್ತು. As it presented, a response counsel is ಮಾತ್ರ.
Council number 31, Rajshekar S, Javed S, Lucas Fury.
For the appellants, my lords, appeal is filed by the wife, my lords. By the MC number 5945 of 2017 on the file of additional principal judge, family court, my lords. I have placed the ex parte order in this case, my lords.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನು he is a man and no disability, why?
Here he appeared in party in person, my lord. Subsequently, he has taken time to engage, my lords, or to
ಯಾಕೆ
seek
ಅವ್ರಿಗೆ
permission.
amicus curiae ಕೊಡ್ಬೇಕು ಅಂತ?
A notice or warrant may be available, one may be issued to the.
ವಾರಂಟ್ ಕೊಡೋದ್ರಲ್ಲಿ ಸಿವಿಲ್ ಮ್ಯಾಟರ್. ಅಲ್ಲಿ ಯಾಕೆ amicus curiae ಯಾಕೆ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರು ಅದ್ರಲ್ಲಿ?
Since he was not represent, he was appearing in party in person, my lords, earlier. Subsequently, he discontinued and short time.
We understand if they are in custody or some disability,
Please,
physical
please.
disability, old age, any free legal aid entitlement ಬರೋ ಅಂತವ್ರು. ಇವ್ರಿಗೆ having taken ex parte decree ಅಲ್ವಾ?
Ex parte decree, my lord.
Ex parte decree ತಗೊಂಡು ಇಲ್ಲಿ ಬರೋದಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರಿಗೆ why amicus curiae should be given to?
Please, please.
ಮಾಡಿದ್ದಾರೆ. ಇದು ನಾವು ಸ್ಟೇಟ್ ಕಾಸ್ಟ್ ಅಲ್ಲಿ ಕೊಡಿಸ್ಬಿಟ್ಟೇನೆ. Have you read the file? ಇಲ್ಲಾಂದ್ರೆ ex parte decree ನಾವು set aside ಮಾಡ್ತೀವಿ.
Please, my lords.
Yes, ma'am.
I may be relieved, my lords.
ಗಲಾಟೆ ಮುಂದೆ we should appear ಅಲ್ಲ. ದನಕ್ಕೆ ಕೊಟ್ಟಿದ್ದು ಹಲ್ಲೆ ಇಸಿರೋದು. Why it was not served or served and represented ಅಂತ ಹೇಳಿ. ಅವ್ರ ರೆಕಾರ್ಡ್ಸ್ ಬರ್ಬೇಕಲ್ಲ. PCRs are received. ಕೊಡಿ ನೋಡೋಣ ಏನಂತ ಬಂದಿದೆ ನೋಟಿಸ್ ಅಂತ. Are you aware? What had happened to the notice issued?
I'm not aware of the notice, my lords, because I'm a
Correct.
illiterate, my lords.
Served ಅಂದ್ರೆ ಯಾರ ಮೇಲೆ ಸರ್ವ್ ಆಗಿರ್ತದ? RPN undertakes to file wakalat for respondent issued by RPAD. RPAD served. ಇಲ್ಲಿ TC and RPAD served ಮತ್ತೆ TC unserved ಅಂತ ಬಂದಿದೆ. ಎರಡು ಆಗಿದೆ. ಆಮೇಲೆ ಯಾರೋ ಅಡ್ವೊಕೇಟ್ ಅಂಡರ್ಟೇಕ್ ಮಾಡಿದ್ರು. ಇವ್ರೆ ಯಾರು ಗೊತ್ತಾಗೋದಿಲ್ಲ. ಏನಂತ ಬಂದಿತ್ತು postal endorsement? Have you seen this?
But notice is served and unrepresented, my lord.
ಎರಡಿದೆ. No. ಅಲ್ಲಿ
Correspond number one.
C ಅಂತ ಹಾಕಿ and RPAD served ಅಂತ ಒಂದು ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಇದೆ.
RPD is.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ. ಆಮೇಲೆ ಕೆಳಗೆ TC ಅಂತ ಹಾಕಿ ಅನ್ಸರ್ವ್ಡ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಎರಡು ಹೇಳಿದ್ದಾರೆ.
In judgment at para number 8, it has been observed that it has been served and.
ಅವ್ರು ಬರ್ಕೊಂಡಿದ್ದಾರೆ. ಬಟ್ ಇಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲೂ ಹಾಗೆ ಬರ್ಕೊಂಡಿದ್ದಾರೆ. We have to verify that also. ಸರ್ ಇದ್ರಲ್ಲಿ C ಫೈಲ್ ಅಂತ ಒಂದಿರುತ್ತೆ. ಹಾ ಇಲ್ಲ. ಕಸ್ತೂರಿ ವೈಫ್ ಯಾರೋ ಕುಮಾರ್ ಲಕ್ಷ್ಮಣ್ ಅನ್ನೋರ್ ಮೇಲೆ ಸರ್ವ್ ಆಗಿದೆ. ಅವ್ರ ಮೇಲೆ ಕುಮಾರ್ ಲಕ್ಷ್ಮಣ ಗೋಪಾಲ್ ಲಕ್ಷ್ಮಣ. It is not served on Kasturi. Somebody others have signed on that postal acknowledgement. Court notice
Gopal Lakshman is father, my lords.
Gopal Lakshman is her
Father.
Kasturi. ಅವ್ರ ಅಡ್ರೆಸ್ ಯಾವ್ದು? ತಂದೆ ಅಡ್ರೆಸ್ ಯಾವ್ದು?
Haliyal village, Athanadli Taluk, Belgaum district.
ಯಾವ್ದು? ಅಲ್ಲಿಗುಲಿ ವಿಲೇಜ್
ಅಥಣಿ ತಾಲೂಕ್ ಬೆಲ್ಗಾಂ ಡಿಸ್ಟ್ರಿಕ್ಟ್
ಫಸ್ಟ್ ಟೈಟಲ್ ಅಲ್ಲಿ ಅದನ್ನೇ ತೋರಿಸಿದಾರ.
ಕಾಸ್ಟ್ ಟೈಟಲ್
ಗೋಪಾಲ್ ಲಕ್ಷ್ಮಣ್ ಲೋಕೂರ್ ಹಳಿಯಾಳ್ ವಿಲೇಜ್. ಅದಲ್ಲ ಸರಿ, ಅದು ಥಂಬ್ ಮಾರ್ಕ್ ಇದೆ ಅದ್ರ ಮೇಲೆ. ಇವ್ರು ಪೋಸ್ಟ್ ಆಫೀಸ್ ಅವ್ರು ಯಾರೋ ಇಲ್ಲಿದೆ ನೋಡಿ, ಸಾರಿ, ಥಂಬ್ ಮಾರ್ಕ್ ಇದೆ, ಅವ್ರ ಸಿಗ್ನೇಚರ್ ಅಲ್ಲ. ಅದನ್ನ ಯಾರೋ ಎಂಡಾಸ್ ಮಾಡಿದ್ದಾರೆ, ಗೋಪಾಲ್ ಲಕ್ಷ್ಮಣ್ ಅಂತ ಹೇಳಿ. That case it can be set aside and fixing a time for disposal.
please.
Yes, anything else you want to submit?
Nothing, my lords. Like without made the evidence and without appreciate the material facts on the records, they have placed the set aside, my lords. Kindly.
One more question.
Civil petition is allowed before the principal judge family court is hereby withdrawn and same is transferred to principal senior civil judge Athani. ಓ ಮೊದಲು ಬೆಂಗಳೂರಲ್ಲಿ ಫೈಲ್ ಮಾಡಿ ಆಮೇಲೆ ಅತನಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗ್ತಾ ಇದೆ ಕೇಸ್. ಮತ್ತೆ ಇದು ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದ್ದಿದೆ ಅಲ್ಲ ಇಲ್ಲಿ. This civil petition order is passed on 7th December 2018. Impugned judgment ಅಲ್ಲ 20th July 2018. ಈ ಸಿವಿಲ್ ಪಿಟಿಷನ್ ಪೆಂಡಿಂಗ್ ಇರೋದನ್ನ ಸಪ್ರೆಸ್ ಮಾಡಿ R1 held sufficient. ಅಷ್ಟು ಇಲ್ಲಿ ಸಿವಿಲ್ ಪಿಟಿಷನ್ ಆಗ್ಲೇ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡೋದಕ್ಕೆ ಆರ್ಡರ್ ಆಗಿದ್ದಾಗ ಅಲ್ಲಿ
Arjun Bangalore.
24. Paying to transfer the case from the Principal Judge Family Court, Bangalore.
MC number 5945.
5945. So it shows that she had the knowledge. This could be the claim. Yes, sir.
ಇದು ಡಿಸೆಂಬರ್ದಲ್ಲಿ ಆಗಿದೆ, ಜುಲೈದಲ್ಲಿ
ಇಲ್ಲ, ಆರ್ಡರ್ ಆಗಿದೆ. ಆಕೆಗೆ ಅದರ ನಾಲೆಜ್ ಇರಲಿಲ್ಲ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ. She has filed transfer petition. She has filed transfer petition in 2018. Are you aware of it or not? She had filed a transfer petition.
Yes, ma'am.
So that goes to show that you were aware of the proceedings.
MC number 5945, my lords.
Not that.
I'm not aware of about
DP.
that case, ma'am. No, my lords.
7th December and this is 20th July. ಇದು ಯಾವಾಗ ಫೈಲ್ ಮಾಡಿದ್ರು ಅಂತ ಗೊತ್ತಾಗಲ್ಲ. ಈ ಜಡ್ಜ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ಸ್ ಮಾಡಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡಲ್ಲ.
CP records ತರಿಸಿ.
CP records, there was a CP file.
Transfer.
ಬಹುಶಃ ಗೊತ್ತಿರ್ಲಿಲ್ಲ ಅಂತ ಅನ್ಸುತ್ತೆ. The records, the trial court records show that. So, when the matter is taken up for admission, it is noticed admission, right? Notice that the appellant had filed CP number 1,67,000 of 2018 for transfer before Dharwad bench for transfer of MC number 5945 of 2017, out of which this appeal arises. And that full stop under in the same said CP, she had sought transfer of MC number 5945 of 2017 from Family Court, Bangalore to Senior Civil Judge Court, Athani. That petition was allowed on 7/12/2018. The impugned ex parte judgment is passed on 27/2018. Registry shall put up the records of the 18 ಇರುತ್ತೆ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಮಾಡ್ತಾರೆ. ಧಾರವಾಡ ಬೆಂಚ್ ಅಲ್ಲಿಂದ ತರಿಸ್ಕೋಬೇಕಾಗತ್ತೆ. ವಿಲ್ ರೆಫರ್ ದಿಸ್. ಮತ್ತೆ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿಂದ ಇಲ್ಲಿ ಬರ್ಬೇಕು ಅಂದ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ.
ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿಬಿಟ್ಟು ಪ್ಲೀಸ್.
ಇಲ್ಲಾಂದ್ರೆ ಅದು ಹಾಕಿ
ಬಿಡಿದಲ್ವಾ
ಹಾರ್ಡ್
ಅಡ್ಮಿಟ್
ಅಡ್ಮಿಟ್ ಬೇಡ. ರೆಕಾರ್ಡ್ಸ್ ಅಂತ ಬಂದ್ಬಿಟ್ಟಿದೆ. ಇಲ್ಲಾಂದ್ರೆ ಜಡ್ಜ್ಮೆಂಟ್ ಡಿಕ್ಟೇಷನ್ ಮಾಡಬೇಕು. The matter is taken up for both for final disposal with the consent of both parties, both counsel, both sides. Heard. This appeal is filed by the wife challenging the ex parte decree of resolution of the marriage of the appellant and respondent on the ground of cruelty and desertion before the trial court. One year ಅಂತ ಮಾಡಿ. Petition 1 year is cruelty. 1 year ಅನ್ನೋದು one year. ಇಲ್ಲ ಹೊಡೆದು ಹಾಕಿದ್ದಾರೆ ನೋಡಿ. ಏನು ಮಾಡಿ on the ground ಬಹುಶಃ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡುವಾಗ ಅವರು ವ್ಯಕ್ತಿ ಮಂತ್ರಿನೂ ಮಾಡಿದ್ದಾರೆ. on the ground of cruelty ಅಂತ ಅಷ್ಟೇ ಮಾಡ್ತಾರೆ. Whereas appellant had not contested the matter before the trial court, that an ex parte judgment and decree was passed against her. The trial court records show that the appellant had filed CP number 1,67,2018 before Dharwad bench of this court, seeking transfer of MC number 5945/2017 from the file of 5th additional principal judge family court trial court /trial court to the court of principal senior civil judge Athani on the ground of her hardship to travel from Athani to Bangalore. ಇನ್ನೊಂದು ಅಲ್ಲೊಂದು ಅವರೊಂದು ಕೇಸ್ ಹಾಕೊಂಡಿದ್ರ there is
OS is one pending.
conflict of decision ಬರೋ ಚಾನ್ಸ್ ಇದೆ ಅಂತ ಹೇಳಿ ಮಾಡಿದಾರಲ್ಲ, ಅದೇನಾಗಿದೆ? that case is still pending.
Suit my lord, OS suit.
And financial hardship. Specific contention that she has filed final miscellaneous so and so for monthly maintenance. The records further show that the appellant had prepared criminal miscellaneous number 279 of 2017 before the civil judge and JMFC Athani seeking maintenance. And what happened to that civil criminal miscellaneous case 125? I don't have the document. This court had allowed CP number 1,67,000 of 2018 by order dated 7/12/2018, transferring MC number 5947 of 2017 to the court of principal senior civil judge Athani in CP number 1,67,000 of 2018. Respondent was though served, did not represent, did not appear and contest the said petition, though he was pursuing MC number 5945 of 2017 before the trial court. Considering the aforesaid facts and circumstances, satisfied that the appellant had insurmountable difficulty in appearing before the trial court to contest the matter. She is required to be given a fair opportunity Therefore, let's submit case to set aside the impugned judgment and decree of impugned judgment and decree of divorce and remand the matter to the trial court. ಅಲ್ಲಿಗೆ ಕಳಿಸ್ಬೇಕು ನಾನು ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕಳಿಸ್ಬೇಕು ಅಲ್ಲ ಇವ್ರಿಗೆ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟು ಅಲ್ಲಿ ಕಳಿಸಂತ ಹೇಳ್ಬೇಕು. Why notice should be issued to him again?
Not required.
ಈಗ ಇಲ್ಲಿ ಎಕ್ಸ್ಪರ್ಟ್ ನಿಮಗೇನು ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಕ್ ಆಗಿಲ್ಲ ಅಲ್ಲ.
No, my lords.
Then again, the trial court has to issue him a notice and secure him. That is the difficulty. Now we have to remand it to the trial court. Trial court has to transfer it
issue
to the
notice.
principal judge, senior division attorney. ಅವ್ನು appear ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ trial court shall take necessary steps. In accordance with law ಅಂತ ಹೇಳೋಣ ಅಷ್ಟೇ. ಅಲ್ಲಲ್ಲ ಅವ್ನು ನೋಟಿಸ್ ಕೊಟ್ಟು ಅವ್ನು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ we can proceed to dismiss the petition. Hence the following order. The appeal is allowed. The impugned judgment and decree dated 27/2018 in MC number 5945 of 2015. Passed by the 5th additional principal judge family court is hereby set aside. The matter is remanded to the trial court. ಅದಕ್ಕೆ ಇಲ್ಲೇ ಹೋಗುತ್ತೆ ನಾವು ಅಲ್ಲಿ ಕಳ್ಸಕ್ಕೆ ಬರೋದು ಇವ್ರ ಫೈಲ್ ಅಲ್ಲಿ ಕಳಿಸ್ಬೇಕು. The trial court shall secure the ಅವ್ರಿಗೆ ಕಷ್ಟ ಆಗುತ್ತೆ ನೋಟಿಸ್ ಕೊಡಕ್ಕೆ ಯಾಕಂದ್ರೆ ಇವ್ರು ಬರೋದೇ ಇಲ್ಲ ಅವಾಗ.
Secure ಮಾಡಕ್ ಕಷ್ಟ ಆಗುತ್ತೆ. And the right now status of both the parties, even it is not been known, my lords. Matter is of 2017.
Correct. We have to send this matter to the family court Bangalore.
Please.
Bangalore court has to transfer it to family court Athini. ಅವರು ಮತ್ತೆ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕು ಅವ್ರಿಗೆ because he has not appeared here.
Yeah.
It would be difficult for them to secure him. Are you aware what he is doing? ಎಲ್ಲಿದ್ದಾರೆ ಏನು ಅಂತ ಗೊತ್ತಿದೆಯಾ? He is employee of BHE ಅಲ್ಲ. Age about 30.
Age about 30 years and 26 years, my lords.
ಮಲ್ಲೇಶ್ವರಂ ಬೆಂಗಳೂರು ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಡ್ರೆಸ್. ಈ ನೋಟಿಸ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಏನ್ ಕೆಲಸ ಮಾಡ್ತಾರೆ ಏನಂತ ಬಂದಿದ್ಯಾ? ಡಿಪೋಸಿಷನ್ ಅಲ್ಲಿ ಏನ್ ಕೆಲಸ ಟೌನ್ಶಿಪ್ ಮೈಸೂರು ಲ್ಯಾಂಡ್ಸ್ ಮಲ್ಲೇಶ್ವರಂ. ಇನ್ನ ಸ್ವಲ್ಪ ನೋಡ್ಕೊಂಡು ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡ್ಬೇಕಂತ ಹೇಳ್ತೀನಿ. ಇಲ್ಲಿ ಯಾರಿಗೋ ನೋಟಿಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದಾರಲ್ಲ ಹೂ ಹ್ಯಾಸ್ ಇಶ್ಯೂಡ್ ಗೊತ್ತಿಲ್ಲ ನನಗೆ ರೆಪ್ಯುಟೇಷನ್. ಪಡನಾಡ್ ಸಿಹಿ ಪಡ್ನಾಡ್ ಅವ್ರವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಟಿಸ್. ಅವ್ರಿಗೆ ಸರ್ ಎರಡೇ ಸರಿ ಸರ್ ಓಕೆ ಸರ್ ಏನಂತಂದ್ರೆ the trial court ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ತಿದ್ವಿ ಟೆಲಿ ಕೋರ್ಟ್ನವರ ನೋಟಿಸ್ ಇಶ್ಯೂ. The trial court shall transfer the file. The trial court that is on the matter is remanded to on the remanded to the 5th additional principal judge family court Bangalore. The said court shall transfer the petition in MC number petition along with the records in MC number 5945 of 2017 to the principal senior civil judge Athini in compliance with the judgment in CP number in judgment dated 7/12/2018 in CP number 1,67,000 of 2018. ಬಂತು ಯಾರಿಗೆ ಬಂತು ಅಲ್ಲಿ ಹೋದ್ಮೇಲೆ ವಿಶಾಲ್ ಅಪಿಯರ್ ಅಂತ ನೋಡೋಣ ಆಫ್ಟರ್ that the appellant ಅದನ್ನು ಬರ್ಬಿಡಿ within ಅಂತ within 2 months within a period of 1 month the from the date of the receipt of these records on such transfer the parties ಅಂತ ಬರ್ಬಿಡಿ appellant ಅಂದ್ರೆ ಬರೀ wife of ಅಷ್ಟೇ she is respondent there the appellant, she let her appear, notice. The appellant, there were 2 parties on, I don't hear you. What he has done, deleted a file. Appellant shall appear before the principal senior civil judge, Athini, on the 2 months bit on date. 5/8/2024. ಹೀಗೆ ಪಾರ್ಟೀಸ್ ಅಂತಾನೆ ಬರೆಯೋಲ್ಲ ಅವ್ನು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೋಟಿಸ್ ಕೊಡ್ಬೋದು ಪಾರ್ಟಿ ಶಾಲ್ ಅಪಿಯರ್ ಬಿಫೋರ್ ದ ಪ್ರಿನ್ಸಿಪಲ್ ಸಿವಿಲ್ ಸೀನಿಯರ್ ಡಿವಿಷನ್ ದ ಪ್ರಿನ್ಸಿಪಲ್ ಸೀನಿಯರ್ ಸಿವಿಲ್ ಜಡ್ಜ್ ಅತನಿ ಆನ್ ಎಷ್ಟು 5/8 ವಿತೌಟ್ ಫರ್ದರ್ ನೋಟಿಸ್ ಇಫ್ ದ ಅಲ್ಲ ಅವ್ರಿಗೊಬ್ಬರಿಗೆ ಮಾತ್ರ ಇಫ್ ಅಲ್ಲ ಸಿನ್ಸ್ ದ ರೆಸ್ಪಾಂಡೆಂಟ್ ಹೂ ಇಸ್ petitioner in the trial court proceedings fails to appear, the trial court shall secure issue him court notice and proceed in accordance with law.
The transfer petition came to a load subsequent to the dictum.
Adra petition pending ittu anta
Pending.
the knowledge can be improved. Now records put up madasko we thought of securing those records. That is in Dharwad bench. 2018 matters, these are CPs, whether records are preserved or not, we do not know. The court places on record the able assistance rendered by Shri Javed, learned amicus curiae. Registry shall pay him amount, pay him remuneration of 15,000. This is
Appreciation is sufficient, but amount is not.
we know he is always, even in criminal cases, 15,000. 15,000.
Obliged.
Number 32.
And I yes, most of the criminal cases. Dinesh Kumar Rao ke
Abdul Ansari.
Appearing for appellant, my lord.
R1 and R.
but this was just ಅದನ್ನು ಬರ್ಕೊಂಡು the charges of the trial court shall recover the charges costs of amicus curiae by the petitioner from the petitioner before the trial court. Yes.
Appearing for appellant, my lord. Lordship. 32. Lordship, appellant had filed a guardians and wards act before the trial court, seeking custody of the minor child. And my lord, the trial court has dismissed the guardians and wards act, my lord, on the ground that the appellant has not proved his income, and also the child was 5 years old, my lord, and the child is baby boy, my lordship. Now, my lordship, I'm seeking custody of the child on the ground that, my lord, respondent number 1, she's the wife. She has remarried to some other person, my lordship. And
What about you?
Sorry,
What about you? You are remarried or not? Then what is the
Lordship,
parity?
my lordship, I'm not aware of that, my lordship, but what has happened
We'll
is,
come
my
up
lord,
with instructions. I
Please,
think
my
required
lordship.
records in the confirm. ಅಲ್ಲ records. TCS. Heard admit call for TCS. Learned counsel for the appellant shall find the affidavit of the appellant and the next year in date about if he has contracted second marriage.
And also, my lordship, one submission, respondent number 3, the grandfather is also expired. Now, the grandmother, she's looking after the child.
ಅದನ್ನ
And
ನೀವು
also, ಇವರು ಕೂಡ ಮದುವೆಯಾಗಿ ಬೇರೆ ಕಡೆನೇ ಇದ್ದಾರೆ, ಮ್ಯಾಟ್ರಿಮೋನಿಯಲ್ ಇದ್ರಲ್ಲೇ ಇದ್ದಾರೆ.
ಅಲ್ಲ ಇಲ್ಲಿ ರಿಪೋರ್ಟ್ ಮಾಡಿದ್ರ ನೀವು ಡೆತ್ ಆಫ್ ದ ಥರ್ಡ್
ಹೌದು, ಮಾಡಿದ್ದಾರೆ.
But the appeal memo, then his name is not deleted.
No, my lordship, it is there. Party ಮಾಡಿದ್ದೇನೆ. Respondent number 3 is N.A. Umar Shafi. Respondent number 2 is Khaira Unnisa.
Appeal against stands abated.
ಹೌದು.
There should be some endorsement in the appeal memo. Beginning. Beginning. It is noticed that appeal against respondent number 3 is abated due to his death. Appellant's counsel shall make a note of the same in the appeal memo, so that it becomes easy.
Please,
As it is. Please count. Now, this is from which court?
My lordship, it's a Mangalore.
Bangalore.
Mangalore, my lordship. First additional principal.
Mangalore.
Judge. Mangalore.
4 weeks at a time.
Please. 8-7. Much obliged.
Cell number 33, B. Sudhakar, KB Loknath.
For the appeal and my lord. My lord, in this case, my lord, we are challenging the award passed by the senior civil judge.
Of limitation.
Please, my lord.
On the ground of limitation of reference application was in time.
It was in time, my lord. It was in time, but only based on only one parity, my lord, that is MFA number 1556, my lord, they have granted the compensation, enhanced the compensation, but they have not produced any document to show that what they were growing there. And
Similarly
similarly is there or not.
Evidence is not reduced regarding that.
Regarding that, they have not adduced any evidence. Only they have.
Survey numbers of both. That
It is
property-
totally different, my lord.
Another contiguous lands or contiguous lands or
No.
far away?
Far away lands.
That's what's one. No representation for the respondent. Even government pleader will respondents.
Idhar.
ಎಲ್ಲಿದ್ದಾರೆ? I admit TCRs already will. Post for final year.
That MFA copy is there, MSA copy, MFA and FA.
MFA, it is there, man. They have produced. They have produced.
Cell
number 34.
They have to prove that they are similarly situated lands. Certified copy of the payment receipt. Exhibit P9.
Cell number 34.
Madam, it is also similar case, madam. It is also based on the same
Same common award.
common award. Bere.
Many
But-
number, in that many number of LIC cases.
LIC cases are there, but this is not connected to that case, my lord. But in this also, my lord,
Records. Idrali, but claimant is served unrepresented.
house.
Two reference, same MFA. Same MFA number is.
Same reference.
Claimant representation ಇದೆ. ಇದರಲ್ಲಿ third admit conflict. First final is
Please.
ಬನ್ನಿ ನಾವು ಕಾಲ್ ಮಾಡಿದ್ವಿ.
For further hearing, cell number 35, Revati Adinath Pette.
FA for respondent, my lord.
Kumar Valsad, sitting time.
My lord, this appeal is filed, my lord.
Last week, your lordship has heard the matter. The other side was not there. Matter is adjourned to today. It's an ex parte order taken by husband playing a fraud on the wife. So this honorable court has admitted the matter, condoned the delay, and the interim order has been granted, my lord.
You are
I-
seeking adjournment in the morning, we said.
No, my
that
lord,
My lord, this matter-
I make my submissions, my lord.
you may
I make my submissions.
Yeah.
My lord, kindly, the major
That's,
ground, I'll lead in the
My
appeal.
appeal, I think I should be
I think
submitting.
it's in
You
record,
said you
so
have
that it's
submitted.
concluded.
No.
It's okay, it's
He
okay.
just made few submission. Other side was not there. Your lordship adjourned the matter. So the matter was not heard. It was just a few sentences were spoken.
All,
Few points I will highlight, my lord, after the lordship can hear them.
yes.
It's a ex parte order obtained by the husband, staying with the wife, my lord.
Hmm.
This is, they have a child out of the wedlock, which is 11 years as on today. Your lordship may kindly see, this is on the ground of cruelty, which he has filed. He was lordship may kindly see the order passed by the court.
the family court, page 13 it starts. It is absolutely on the ground that the wife did not appear and she did not, she remained absent after being served and she did not file any reply. So whatever the husband has asked, I'm granting it. That is the lines it has gone. Cruelty has to be proved, my lord, which has not been done in this case. And the documents I will show before your lordship, what has been marked is nothing pertaining to that. Your lordship may kindly see one crucial thing, page 32 of the order, my lord. The order passed by the trial court at page 32. That's quite crucial thing which I would like to highlight. How to prove that husband was staying with the wife and took the divorce order behind her back. Page 32, if your lordship may kindly go 1, 2, 3, 4, 5.
Yes, yes.
6, 7. 8th line, I will read from there. 8th line. On account of the aforesaid mentioned acts of cruelty meted out to the petitioner, he is not in a position to live with the cruel respondent anymore. Petitioner and the respondent are living separately since 28/7/2018, which is a false statement. Your lordship, kindly see the memo which I filed it, and I produced a medical document whereby an abortion has taken place.
Last
Your
year
lordship,
mentioned that.
yes, my lord. Abortion date, if your lordship may kindly see, it is 12/4/2019. And he says he is living separately from 28/7/2018. How it is possible, my lord? So he stays with her and he takes a order, and elders sit across and he says he will withdraw. He's staying very much with the wife. I will produce few of the judgments. Before that, my lord, he makes one more, the court also records one more statement that he's taking care of the wife and the kids, which is also not true. Your lordship may kindly see page 33. Page 33 and para 13. Last few lines. However, the petitioner also relied on P5 original school bills pertaining to expenses incurred by the petitioner with respect to the daughter, which are 11 in numbers, to show that he is paying the school bills and other expenses incurred by the daughter. Further, the petitioner proved that he is staying in a rented house and all these things, my lord. I would like to produce few documents. I'll give a copy to the other side also, where I have approached this honorable court, honorable family court for the GNWC proceeding. Both are there in GNW proceedings, and interim maintenance has been granted, ma'am. Your lordship may kindly see this document.
Now we are producing.
No. That is in another proceeding. Why? What I want to demonstrate, maintenance, he says he's giving, he's taking care of the child, which is not true. Maintenance is also not given. The honorable court granted interim maintenance. If your lordship may kindly see the document which I produced before your lordship. This is in the GNWC proceedings by both.
February 2024.
Which one, my lord?
This order is passed on 28th February.
24. Maintenance, my lord?
This judgment is passed
on 20th February 2024. That is, the proceeding is still going on. Custody case is going on, my lord. In this, if your lordship may kindly see the last page, there was a, your lordship may kindly see the judgment, page 6. Page 6, my lord. Down, if your lordship can kindly see, in between. The court below has considered all the facts and granted only 15,000, which is not sufficient for both wife and the daughter. In view of the matter concerning the affidavits and assets and liabilities, also the school fees and other requirement assets and liability statement shows that she is paying 72,000 EMI and other thing. Writ petition is allowed. Respondent is directed to pay a monthly maintenance of 40,000 rupees. He's not paying even 1 rupee to the child. He's around sitting in Spain and enjoying his life, my lord. He has taken a divorce. He is very happy. If your lordship may kindly permit me to produce 2 judgments of this honorable court itself, whereby in a case of cruelty, in case of cruelty, it has to be proved, and ex parte decree cannot be maintained. Your lordship has passed similar orders. I will just take your lordship to 2 judgments. And your lordship sees the judgment of this honorable court itself, my lord. First judgment, page 9, my lord. Your lordship gets it, my lord?
Yes.
Page 9. Para 9, page 9, my lord. A perusal of the judgment discloses that The learned trial judge has neither appreciated the evidence nor the documents placed on record by the respondent husband. This is also a similar cruelty case, my lord. It is the duty of the trial court to examine the material on record and to examine whether person who approaches the court have made out a case for granting divorce on the ground of cruelty without examining as to whether the respondent husband has made out a case for divorce on the ground of cruelty. Learned trial judge proceeded to allow the petition only on the ground appellant wife has remained absent and she has not filed any response. The said procedure followed by the trial court is wholly erroneous and the reasoning given is totally perverse. The reasoning part of the judgment contains only 2 paragraphs. At para 10, the trial judge noted that the facts and evidence at para 11, the trial judge gives reason for allowing the petition, placing appellant wife ex parte and non-filing of the objections by the appellant wife. Non-appearance and non-filing of objections could not be a reason to allow the petition under 13, it is 31 IA, my lord. In the beginning, it is there, of the Hindu Marriage Act. When the petitioner makes out a case and prove the allegation of cruelty, then only the court could grant the decree of divorce or annul the marriage. The respondent husband has failed to prove the ground of cruelty by examining any independent witness or placing any cogent evidence only on a self-serving statement of the respondent husband. The trial court could not have allowed the petition. The second judgment which I'm relying is passed by this honorable court itself, my lord, on 5th December 23. The relevant paragraph is at page 5, para 8, my lord. Para 4 reads that this is a decree of divorce on the ground of cruelty. Then the para 8 at page 5, my lord.
It is only submission.
Only submission.
Just to prove that it's a similar thing. I'll come to the main paragraph, my lord, which is the last paragraph, my lord. That is para 21, my lord. 21, internal page is 12, my lord. First of all, the respondent should be given an opportunity of meeting those documents. Secondly, even as per the communications, the respondent was proposing for dissolution of marriage by mutual consent, and she was seeking in terms of a settlement. Petitioner was asking her to contact. After this, my lord, para 23, 23, my lord. Needless to say, the marriage is a sacrosanct institution. Couple had 13 years of marital and 2 children. In such cases, she should not be thrown out of such institution without being heard. Therefore, it is a fit case to allow the appeal and remand the matter. This is passed by this honorable court, ma'am. Few documents I will refer, and after that, my lord, I will conclude my arguments. Your lordship may kindly see my appeal, my lord. In my appeal, in the judgment, that is at page 38 is the documents, my lord, in my appeal, my lord. The documents relied by the Honorable Family Court, my lord. Page 38, my lord. Internal page 26. The last page of the judgment. Documents. Your lordship gets, my lord?
Annexation.
It's the judgment of the trial court, last page, my lord, where the documents are marked. Page 38. Wedding invitation card, original certificate or registration of marriage, birth certificate of the child, home loan agreement, school bills, original receipts pertaining to home rent, pertaining to medical expenses, printout of email, printout of statement of accounts, medical reimbursement form, and certificate under 65B. There is no document pertaining to cruelty. Absolutely. Absolutely, there is no documents and there is no evidence, like no witnesses marked. And the trial court has concluded just because she remained.
Cruelty alleged by him.
My lord?
It was the cruelty alleged by him.
Yes, cruelty, my lord. This is under 13(1) IA.
What was the cruel acts alleged by him?
He says she was not behaving well and she was not talking to her mother properly.
She was not taking care of the
Your lordship
husband as
kindly
well as the
come
parents.
Your lordship may kindly see that narration is that
She keep on blackmailing the petitioner, respondent, my lord. Threatening that she is going to kill.
Sir, I think I will finish it and then you can answer it. He has alleged that your lordship may kindly see the narration of the family court comes at page 19, my lord. Down 3-4 paragraphs, my lord, page 19. So page 19, internal page 7, my lord. Para 4 end, my lord. During July 2015, your lordship gets it, my lord, middle of that.
Yes.
The petitioner shared an email to the respondent's sister who was living in US that he's getting tired of his mother-in-law's wrong influence on his wife, respondent, leading to her to fight with the petitioner for not earning enough or changing the job. During August 2015, respondent walked out of the petitioner and their daughter and found a house for herself to stay in because the petitioner has requested his father not to lend money to the respondent brother for buying a house, even though the petitioner has given half the savings, 1.5 lakhs to the respondent's brother. He has been incommunicado for past 2 years, deserting his widowed mother. During March 2016, the work in Canada were under process. Both were saving the money. This is exclusively the dispute regarding the earnings, my lord. Both of them have taken in GNWC proceeding also, entire narration of the facts has come where 2 houses has been bought by both of them jointly. She is paying all the, even today, 92,000 is her EMI, what she's paying for the house. He's not even bothered to turn up. If she doesn't pay the EMI, she'll be thrown out by the DRT proceedings or by the bank, my lord. So she's paying the EMI, she's taking care of the child, he's not to be heard. And this maintenance application also, he's challenging for reopening now. This is the, he is involved in a lot of women. He will put in Instagram all the photographs, which is a part of a record before the Honorable Trial Court and the GNWC proceedings. He's into all type of life, my lord. He doesn't want to take any responsibility. And if at all he's interested that he wanted to take a divorce, he would have allowed her to contest and not taken behind her back. The very fact that the medical certificate proves that he was living with her and cheated on her and taken a divorce, she should be given a chance to prove the cruelty if at all she has done it. So my only prayer before this Honorable Court, based on the judgment which I have relied, it cannot be permitted to go for an ex parte decree where cruelty is not being proved by the other side, my lord. I request this matter may be remanded back to the trial court for the trial, my lord. That's all as my submission.
Let me to continue where she stopped the pleading, my lord, page number 20. Interlinked, my lord, during March 2016. What was the harassment meted by the respondent during the March 2016? The work permit in Canada under process, and both were saving money to make a part payment of for home loan. Even though the petitioner having backed out from spending an amount of a negligible as rupees 2,000 next day, the respondent went to meet a fashion designer to get a rupees 50,000 dress altered at a cost of rupees 16,000. Even though the petitioner had told that the alteration could await, since the event that the respondent required to attend the 3 months from then, and the designer needs to less than 2 weeks to alter, and so it could wait. With no regard to his words nor his feelings and the financial situation, the respondent went ahead and made payment. After this, the respondent again walked out with the daughter on petitioner, refused to give her money to stay separate. She blackmailed the petitioner with threats of committing suicide by implicating him. The cousin sister of the petitioner had stepped in for counseling the respondent, and the petitioner did not escalate the situation for better Canada/on-site stay of the family. The petitioner had gone to Canada, and the respondent and the daughter joined him on 11 July 2016. During this time, the friends and family members of the petitioner had helped the respondent to take care of the daughter when the respondent would go for work and help to pack and vacate the home. But she has ill-treated them. During July 2016, the petitioner would not join the family event from July 6th to 9th and was shocked to find out that his daughter, being the only grand gift for his in-laws, was not even considered for buying a new dress for the marriage event. The respondent did not listen the words of the petitioner in getting the daughter into public library to read something knowledgeable. The respondent was compelling him to pick up and drop to her work spot, where the petitioner was dropping her to workplace. In the meanwhile, he was used to drop and pick his daughter 9 to 10 times. During November 2016, the petitioner wished to get his parents to an international trip and finally planned for the same. A month after respondent started to work in Canada, with the help of petitioner cousin's help, and 4 months after they have been in Canada, the petitioner was busy in making arrangement to accommodate all of them, and he lost track of his expenses to be recovered from his office. Till 7 days, he would have wait to receive salary. He asked the respondent to lend money to take his parents to see around, but to utter despair and shock, respondent bluntly said no. Thus, the respondent was being cruel, and the parents' petitioner had just come there for 4 weeks and have self-financed all the expenses, including the flight tickets. The respondent even was not liking to have a dinner with the parents of the petitioner, and she has expressed the same in front of the petitioner. And knowing the same, the parents of the petitioner have decided to advance their return tickets for flight. The respondent used to ill-advise her to her daughter, again the parents of the petitioner. But the mother petitioner is favorite person to the granddaughter. The respondent used to threaten the petitioner that she is going to commit suicide. The petitioner was afraid of her behavior and made up his marriage to take divorce. On return to India in 2017, the petitioner discussed with the respondent, suggested for counseling, to which she refused, and mentioned her demand for house, which they have purchased jointly, and kids maintenance plus joint upbringing. During the housewarming ceremony of the respondent picked up fight with co-sister and ended up with calling her brother-in-law the brother of the petitioner, and ended up in insulting him with names like beggar, etc. And dragging the petitioner brother and his parent all has been insulting and frustration to the petitioner. Due to the cruel behavior of the respondent, on 14 January 2016, the respondent locked the room with the knife from the kitchen, threatening the petitioner with the threat of she committing suicide. And even after repeated request of the petitioner to open door, she did, confining the petitioner to call in police by dialing 100. And the police come to the house and counseled for an hour. The respondent has not met her financial obligation, for which she received notices from LIC and IT department for non-payment of installments and non-filing of IT return, and paid fine up to rupees 30,000. And due to non-payment of EMI toward the home loan, the bank initiated for action of the plot. The salary being received by the respondent is rupees 1,20,000, but she did not contribute towards the EMI of home loan, and the petitioner was contributing substantial amount towards the loan obligation and towards schooling, upbringing the daughter, well-being of the family, and he will be left with no money. The respondent, except contributing small portion of meeting EMI installments, she spent a thrift. She used all her money for her lavish life. The respondent continued her cruel behavior and threatening the petitioner with false cases. In spite of several counseling by elders, she used to continue the same acts and forced the petitioner to leave the house and to shift his parental home. Thus, from 28/7/2018, the petitioner constrained to live separately with his parents, leaving the respondent and their daughter to live in the flat number so and so, and only visitation rights to visit the daughter. Though the petitioner is meeting the loan obligations of the above-mentioned flat belonging to him jointly with the respondent, he is unable to reside with the respondent with the threat of suicide persistently held by the respondent. Hence, all the respondent want only property and the money of the petitioner, and not the petitioner and his parents. Even they have been treated her with the utmost love and affection, and hearing her and the daughter, well, the respondent showed ill temper and medical instability by scolding the petitioner and his parents without any rhyme and reasons. Thus, the cruel acts of the respondent not only caused immense unbearable mental harassment related to the petitioner, but also completely shattered, and their marriage relationship has irretrievably broken down, and therefore the petitioner is unable to live with the respondent anymore. So on. Now, kindly see they are not disputing the service of the notice. Kindly see the inquiry number 35, my lord, para number 14. In the instant case, the trial court observed, my lord, in the instant case, the notice was issued to respondent through court and by RPD, both, my lord, wherein the RPD was served to the respondent duly, and in spite of it, the respondent has not appeared before the court on the date fixed for her appearance. Therefore, after calling the respondent, she has been placed ex parte as service held insufficient, my lord. Well, these are the facts that was leading to grant of divorce, my lord. My lord, kindly see the main ground alleged by the my lord, the main ground alleged by the appellant is, my lord, that the respondent has played fraud for obtaining the ex parte decree. Kindly see the ground number 4 of the appeal memo.
On whom the notice was served?
My lord,
Trial court records, you have shown her address as
my lord, it is not in disputed. They fairly admitted, my lord.
address
Yes.
shown as flat number so and so.
Yes.
You say you are living in separate
I am
house.
living with my parental house, my lord, though I am a joint owner of the property.
Show that she is living in this flat
It is,
number.
but kindly see the custodial address, my lord.
My lord, the document
Appeal.
says.
Madam, kindly see the cost title address.
No, no, you have shown the address of this HSR layout.
Yes, my lord.
This
Kindly see the
records,
cost title address, my lord, in the appeal.
see what it shows, sir, address, sir.
In
The
before,
same there,
same address, my lord.
and address ಬರೋದೇ ಇಲ್ಲ, మరి
ಅಲ್ಲ ಇಲ್ಲಿ ಬರ್ತಾ ಇದೆ ಮೇಡಮ್, ಇಲ್ಲಿ ಅಪೀಲ್ ಅಲ್ಲೂ ಮತ್ತೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
see what they have produced. There is a question something ಕೊಟ್ಟಿದ್ದಾರೆ.
If your lordship may kindly see the cost title of the judgment of the trial court.
No, no,
He has
just-
conveniently shown his parents' address, not the address he's staying with the wife.
Madam, we ask you one question. You have produced some discharge summary, whether his address is shown there.
Madam, kindly see
That
the
is
cost title address of the respondent in the my lord, in the trial court judgment, my lord. Kindly see the address of the respondent in trial court judgment, my lord.
Saw that was HSR layout and proceedings.
And
Yes, this
and the
hospital.
address shown in the appeal as well as the trial court are one and the same, my lord.
Right, we wanted to see because according to you, she was served and unrepresented.
But it is not been disputed, my lord. She fairly admits that notice has been served.
Service of notice.
Service of
Yes,
notice is
yes,
done to me because I'm living in the same house with the husband.
Yeah,
After receiving, I've even pleaded to that extent. After receiving the
Please
notice,
see the
when I
mail-
asked
mail-
my husband, what is this? Then he said, no, 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 I will withdraw. We will settle everything.
Well,
The
kindly see
proof
the-
is that the proof of that is they were staying together and there is an abortion. Your lordship may kindly see if he's staying somewhere
Well, I will
else.
point out, my lord. My lord, let me
So-
cooperate.
Right, we wanted to ascertain only one thing, whether service of notice was admitted or not.
It's admitted. I've not disputed that.
Kindly, my lord, the only the main ground alleged in the appeal is, my lord, that the respondent has played a fraud on the petitioner to obtain the ex parte decree, my lord. Kindly see the ground number 4, my lord, in the appeal memo, inquiry number 9, ground number 4. I am pointing out only the relevant ground, my lord. This is the main ground they are alleging. Inquiry number 9, para number 4, ground number 4. The appellant submit that the respondent has played a fraud on her and obtained the ex parte decree. The respondent has been staying with the appellant as if everything is settled down as per the advice of the elders and continued his litigation, although he is given a word to the elders that he will withdraw the frivolous case filed by him. The appellant was literally restrained by the respondent from defending the case on the false assurance that it is only filed to scare her and intends to withdraw the same. The respondent cunningly assured the appellant regarding withdrawal of the case and had led evidence on 27/6/2019 and 25/7/2019 as per the order sheet, and left to US after concluding his evidence and did not give a hint to the appellant and revealed about the ex parte decree after lapse of appeal period 27/12/2019. No, my lord, kindly see my objection, my lord. I produced a document along with the objection, Annexure R1.
Section 2,
I filed objections, my lord.
appeal,
Objections, yes, I filed.
to the appeal. you have
Yes,
filed.
my earlier advocate, my lord, filed. Where she produced some document, my lord. Annexure R1. ಇಲ್ಲಿ my lord, ಇವ್ರು ಹೇಳ್ತಾರೆ, she only came to know about the passing of decree on 27/12/2019. My lord, kindly see Annexure R1, your honor, my lord.
ಮೊನ್ನೆ ಒಂದು file ಬಂತು.
Annexure R1,
ಯಾವತ್ತು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ, ಯಾವತ್ತು ಹಾಕಿದ್ದೀರಿ?
my lord, it's on 6/7/2020.
Document ಇದು appearance. 6, 7, yes.
Well, this is a WhatsApp group chatting, my lord. It includes petitioner, respondent, and other family members, my lord. Well, kindly see, date is on 9/7/2019, 17/9/2019. Lord, here, kindly see. Divorce granted by court. This is message by the respondent. Okay, congratulations, you must go celebrate. Let me talk Dhwani. Then Dhwani means my lord, daughter, and congratulate her. She is studying. Dhwani will be with me, right? So what I finally understood was it two-step process, settlement and custody process. My lord, she expect happiness after getting divorce, my lord. She expects happiness. My lord, may kindly see, continue, my lord. You make me feel so and so, so and so. If you feel something is lacking, you can come to take care of this aspect. I am making sure studies, she eats, she plays. That's all enough. It's been raining every single day here. You don't be sit there and give me gyan on what is right and wrong to her. I can only do so much. I need to give at least 30 minutes to myself also. This is important, madam. We are already divorced. It would be good if you stop dictating me what I need to be done. My lord, after knowing the degree of divorce, my lord, she was expressed happiness. And also, my lord, may kindly see where my lord GNWC petition.
ಈ ತರದ ರಿಲೇಶನ್ಶಿಪ್ ನಲ್ಲಿ
ಅಲ್ಲಲ್ಲ, my lord, ಇಲ್ಲೇನಂದ್ರೆ,
right to
my lord,
speak
she made
with
allegation of fraud.
faith.
My lord, she made allegation of fraud.
each other.
Yes.
My lord,
It's
I do agree, my
It's a
lord, I do agree.
sarcastic remark.
She made allegation of fraud, my lord, played on her. But the document clearly shows that she expressed happiness. One thing, my lord, another thing, my lord, the major portion of the EMI is, my lord, paid by the husband, that respondent, my lord. If she paid major portion, my lord, let her put the document, my lord, to show
It
that.
is there, the
she-
document
no,
which
no,
I
my lord.
given.
My lord, let me
You
Check.
said when you were arguing,
My lord,
you
let me
tried
clear,
to-
my lord.
Very well.
you
Very well.
asked him not to interfere. When
Very
he is
well.
arguing, why are you doing?
No, he said document you have
Yes.
produced.
Do one thing.
He asked document you
Madam,
produced.
madam.
I have-
Advocates more than any.
Please, Mala, please, Mala.
One more thing, my lord.
Right, the matters can be settled.
Yes, ma'am.
You should not step into the shoes of the parties.
No, 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 absolutely. no.
Waiting.
My lord, one more thing, my lord. She
And
got,
both of them are employed.
my employee, he is a BBM graduate, he is a B graduate, my lord. Both are well educated.
These things, see, in a fit of anger, ಏನಾದ್ರು ಮಾಡ್ತಿದ್ರು ಕೂಡ later they can, somebody, with the help of somebody, they can settle. Life is very short.
My lord, that being a case,
ಬಂದು ಹೋಗಿದೆ.
Allala, my lord,
Having
if that
learned
being a
this-
case, if my learned friend agrees, let it be referred the matter for mediation.
Matter was
Because
referred to mediation.
I-
It
I-
got
my lord,
failed.
I am not compelling.
This
If
court
she is
itself
willing,
referred to
if he is
mediation.
willing,
It
if
got
he is willing.
Even after this appeal is disposed of also, it can be referred to mediation.
Yes, yes.
But ನೀವು try ಮಾಡಿದ್ರೆ, what we are feeling is, financial distress ಅಥವಾ ಹೆಲ್ತ್ ಏನೋ ಯಾವ್ದೋ ಒಂದು ಫ್ರಸ್ಟ್ರೇಷನ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ಬೇರೆ. Both of them are healthy, wealthy, and they are blessed with a child. ಎಲ್ಲರೂ ಮಾಡಿ ಅದನ್ನ instead of making the feelings bitter, they try, they can settle it.
My lord, we ready for settlement, my lord. And also major portion of the expenses to the child is taken care by the respondent, my lord.
ಮಾಡ್ತಾ ಇರ್ಬೇಕು. Whether she is willing to join.
She is willing to join, madam. She is willing to join.
They are willing to patch up. Joining is one thing, patching up.
Yes.
They are in a mood to patch up. He is in Spain.
Yes, my lord. Right now he's in Spain.
Whether he has any of them have undergone a marriage, second marriage.
I don't have any instructions, my lord, in that regard.
No, no, he is
I
into a lot of women, my lord. There's a documentary evidence.
No, no.
In fact, he has
My
taken.
lord, this is a false
GNWC
allegation, my lord. My lord,
proceeding-
without any document.
My lord, no,
I am opposing, my lord.
he's
I am
not
opposing the
aware of
submission.
that.
One after another we can hear.
My lord,
Both
he-
of them speak.
Well, let her prove.
GNWC proceedings when it was happening.
Listen to us also. If you say that he has extramarital relationship also, still whether she wants to join him.
She doesn't want the marriage institution to break, my lord. They were staying together, my lord, and elders consoled them. And they said, okay, I'll withdraw the case. That is my pleading. I have not created anything new.
He asked you a direct question.
Yes, my lord, I don't want the marriage to break for the sake of the child.
No.
Tomorrow, child's marriage, it will be difficult if she doesn't have a father. She doesn't want to break the marriage. Today also they are fighting.
Not breaking marriage is one thing. Whether they are ready to live together, that is another thing.
She is ready to live together, provided he is interested. He wants to go for fresh marriage. I don't know what I should say. This is what it looks like. He takes behind her back and the learned counsel says she's very happy. It is not happy. It is very sad and sarcastic that you lived with
Document,
me
document,
and then
I
you
refer to the
suddenly give me
document.
a divorce order as a gift.
Well,
No,
I-
no
my
women
lord,
will
I'm referring
accept.
a document where she only messaged, my lord.
Ask you whether there is any, they are living together. That's
She is ready to live, my lord. How I can say on the part
I
of
want to
the,
take instructions, my lord. I want to take instructions.
after hearing the matter for such a long time, my lord.
there should be reason. There is no reasoned order. Any paragraph. Reasoning ಇಲ್ಲ ಬರೀ 2 paragraph.
ಅಲ್ಲ, ಅಲ್ಲ.
Our
ಯೋಗಿ
expert
ಮೇಲೆ ನಾನು-
these are the documents produced, you only read the judgment. All reproduction of petition.
My lord, here the issue is,
Reproduction of-
my lord, here the issue is, my
Even-
lord, this notice was duly served, my lord, both through court as well as RPID.
Even if notice was served, the court should pass a reasoned order. ಇಲ್ಲಿ reasons ಏನಿದೆ 2 paragraphs, last 2 paragraphs, 15 and 16.
Yes, my lord.
15 ನಲ್ಲಿ Respondent has not appeared. Petition has described in detail about the conduct of the respondent. Respondent has not appeared. She has not tested the veracity of the evidence of PW1.
Yes, madam.
That has gone unchallenged.
Yes.
Documents so and so are marked. This is one paragraph. Therefore, it is clear that she has caused mental cruelty. Next paragraph. If there was no truth in the case of the petitioner, she should have appeared and contested the matter.
What?
This is a judgment in rem. He has pleaded certain grounds. ಅದಕ್ಕೆಲ್ಲದಕ್ಕೂ ಏನಾದರೂ ಒಂದು ಅನಾಲಿಸಿಸ್ ಬೇಕಲ್ಲ. This is the document which shows that she has not contributed. She abused her parents. She did not, when they came to, which is that Spain, she did not, she was not hospitable. ಅದೆಲ್ಲದರ ಬಗ್ಗೆ ಏನಾದರೂ ಬೇಕಲ್ಲ. Even assuming that she was served, there should be a reason.
She is a graduate, my lord. She
will set aside and remand it. You are urged the grounds before the trial court. You prove it. Or you can try settlement there also.
A time bound order may be ordered, madam.
Heard both sides. The appeal is allowed. The impugned judgment and decree dated 2/8/2019 in MC number 6362 of 2018, passed by the second additional principal judge, Family Court, Bangalore, is hereby set aside. The matter is remanded to the trial court for fresh consideration after giving reasonable opportunity to both parties. In accordance with.
A time may be fixed.
To avoid further delay, the parties are hereby directed to appear before the trial court on 1/7/2024 without any further notice. If any of the parties fail to appear, the trial court is at liberty to proceed in accordance with law.
A time may be fixed for the disposal. For disposal, madam.
Both the parties shall cooperate for this expeditious disposal of the matter. The trial court shall, on such appearance, the trial court shall give the appearance, date of appearance. Party shall give reasonable opportunity to both the parties and dispose of the matter as expeditiously as possible, at any rate, within 6 months from the date of the appearance of the parties before the trial court. ಅಲ್ಲಿ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ 6 months ಅಲ್ಲಿ ಮಾಡಬೇಕು ಅಂತ ಇದೆ. ನೀವು ಹೇಳೋದ್ಬಿಟ್ಟು ನಿಮ್ ಕ್ಲೈಂಟ್ ಫಾದರ್ ಅಲ್ಲಿಂದ ಕೈ ಮಾಡ್ತಾರಲ್ಲ.
ಅಲ್ಲ ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದೀನಿ ಅವ್ರಿಗೆ.
ಅಲ್ಲ ಇವ್ರಿಗೆ ಅಷ್ಟು ವಯಸ್ಸಾಗಿರುತ್ತೆ. ದೇ ಶುಡ್ ಮೇಂಟೈನ್ ಸಮ್
Publishment.
1/7. Sorry, my lord. 1/7.
regard to the relationship parties, no order has to pass.
I'm sorry, my
One
lord.
upper
Making submission at 1:30.
Serial number 57, I pray for some time, my lord.
My lord, serial number
Reach out.
32.
We have to sit to hear you
36.
on adjournment. You are violating our human rights. Come at.
Filing
My
a
lord,
retirement
serial
memo,
number
my lord, that's
36,
why.
my lord.
No, we'll consider it.
My lord, serial number 36, please, time, my lord. Court officer. Serial number 36, time ಕೇಳಿದ್ದೆ ಏನಾದ್ರು
ಇಲ್ಲ ಮೇಡಮ್. Serial number 36 ಇದೆ.
ಇದ್ಯಾ?